Yes.
Commissioner, we're joined by some representatives of LinkedIn.
If the Commission pleases, I appear with my learned friend Ms Forsyth for LinkedIn.
Yes, Mr. Lynn.
Commissioner, the first witness today is a witness from LinkedIn, Mr. James Patrick Corrigan, who will be giving evidence by AVL.
Yes.
Hello.
Mr. Corrigan.
Yes. Sir, will you take an oath or make an affirmation?
Oath, please.
Oath. Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Please say, I do.
I do.
Mr. Corrigan, is your business address 1000 Westmord Avenue, Sunnyvale in California?
Yes.
And you've given a statement to the Commission dated 5 June 2026 that bears the document ID STAT.899.007.0002. Is that correct?
I gave a statement. I don't have one that's labeled in front of me, but I'm sure that's correct.
Okay. Well, is the statement that you gave true and correct to the best of your knowledge and belief?
Yes.
Commissioner, I tender the statement.
Yes. The statement is stat.899.0077.0002, and it will be received as an exhibit.
And can I perhaps indicate that there are some documents referred to in that statement and some other documents produced in response to a notice that will be tendered at a later time once some confidentiality claims are resolved?
Yes, that's noted, Mr. Sherman.
Mr. Corrigan, you're presently the Vice President Legal with responsibility for digital safety at LinkedIn Corporation, is that correct?
That's correct.
And you've held that role since October 2021?
Yes.
And you commenced with LinkedIn on October 2015, is that right?
Yes, that's correct.
And in your current role, you lead the LinkedIn content policy and legal teams that support the trust and safety, information security and law enforcement functions, is that right?
Yes.
And before joining LinkedIn, you're an attorney in private practice, is that correct?
Yes.
And you hold a JD from the University of California?
Correct.
Now, you've provided your statement in response to a notice issued to LinkedIn Singapore Pte Limited, which is a Singaporean entity. Is that right?
I believe so. Yes.
Okay. And that Singaporean entity, to your understanding, has offices in Australia. Is that correct?
That is correct.
And is it correct that LinkedIn provides its service to about 17 million Australian members?
Yes, I believe so.
And how many users approximately does LinkedIn have worldwide?
Over 1 billion. I'm not all the way up on the latest numbers.
Now, in terms of the services that are provided to LinkedIn users on the platform, are they provided by LinkedIn Corporation?
In Australia, they are, yes.
Okay. And in terms of LinkedIn's presence in Australia, it has more than 200 full-time staff, is that correct?
To my knowledge, yes.
And the majority of those staff are in sales-related roles, is that correct?
Yes, I believe so.
Others are in finance, human resources, marketing, communications, and public policy roles, is that correct?
I believe so, yes.
Are there any trust and safety staff that are located in Australia?
No.
Okay. And what role does the entity LinkedIn Singapore Pte Limited play in the LinkedIn Group's operations?
That I don't know. I'm not an expert on our corporate formalities.
Now, you give evidence that members of LinkedIn use the platform to find jobs, learn skills, and make connections with other members, is that right?
Yes.
And members need to feel secure, confident, and in control of how they engage with LinkedIn?
Yes.
And the content that they post on LinkedIn is tied to their profile and can be seen by other members, is that right?
Yes.
And those other members include current and future employees, colleagues, and business partners, is that correct?
They can, yes.
And it's also correct that LinkedIn doesn't allow parody accounts or anonymous accounts. Is that right?
Yes.
And I think you give evidence that LinkedIn differs from some other global platforms in that it's a real identity platform that has a professional focus. Is that your understanding?
Yes.
Do you accept in those circumstances that the presence of hateful or derogatory content on LinkedIn, when directed at an identified individual, may have a greater capacity to cause harm than similar content on other platforms?
I'm not sure. It could.
But if hateful content is directed at a person whose identity is real and known in the context of a platform that is designed for professional connections, you would surely accept that that content has the capacity to cause harm to an individual.
Oh, certainly, yes.
Does LinkedIn have reason to believe that the requirement to use one's true identity means that breaches of its policy are less common than it might be for other platforms?
It depends on what you mean by reason to believe. I think it's intuitively correct that because we are a real identity platform of a professional nature, people are generally less likely to act and behave on the platform in an unprofessional manner. That's what LinkedIn is about. It's all about work, and so I think it's generally correct that people tend to bring their best selves, so to speak. But of course, these are not hard and fast rules.
Certainly. And you give some evidence that LinkedIn has a global team of policy researchers, writers, and implementation specialists who set and enforce content standards. Do you recall giving evidence to that effect?
That is correct.
And that's the part of the LinkedIn business that you're engaged in yourself, is that right?
Well, so that is a reference, I believe, in part to the content policy team, which is part of my team, yes.
Okay. And does the content policy team have any staff that are located in Australia?
No.
What processes does LinkedIn have in place to ensure that Australian community values are appropriately recognised and dealt with in its content moderation policies?
Well, we're a global platform. Our policies apply globally. We do issue what's called regional guidance. So in situations where it may not be obvious to reviewers that a particular language or issue has a specific impact in a region, there will be guidance issued to the reviewers so that they will understand that. But there is not a kind of formulaic process for that is constantly intaking input from all regions, if that makes sense.
Certainly. And in terms of the regional guidance, what region is Australia in for the purposes of the issuing of that guidance?
I don't follow. What do you mean?
Well, you said earlier that guidance is issued on a regional basis, and what I'm seeking to understand is what other countries are aggregated with Australia when guidance is issued with respect to Australia.
Oh, I see. I wouldn't think of it that rigidly. What I'm trying to explain is a distinction between the fact that our content policies do apply globally. So there aren't separate content policies for various regions in the world. However, that doesn't mean that we won't intake region-specific issues to issue guidance to reviewers. But that's not done on a like a set, these countries are part of this region type of framework. It's more just what's happening around the world, and is there something in a particular region, however we define it, that needs special guidance.
So these content policies that are distributed might relate to different regions depending on the issue that they're dealing with. Is that your evidence?
Can you say that again? I didn't quite track.
So when a content policy is issued, the regional scope of that policy might vary depending on the specific issue that guidance is directed at. Is that right?
Oh, I see. The reason I was confused is the semantics. So the policies. So I want to distinguish between policies and guidance.
Certainly.
The policies are global. We will issue interpretive guidance of the policies if needed to help reviewers understand a regional distinction or something unique that's happening in that region that's relevant to their policy decisions.
Okay, I think I understand that evidence. Now, in terms of the employees that are engaged in LinkedIn's trust review operations, I think you give evidence that there are 180 such employees. Is that right?
There are about 180 full-time employees, and then there are, I'm forgetting the number, like either 1,500 or 1,800 contracted employees that do that.
Certainly. And so are those employees and contractors, the employees and contractors that moderate content, is that their function?
Yes.
And where are those employees and contractors based?
In multiple locations, excuse me. I don't have the exact locations committed to memory, but I can tell you there are none in Australia.
Okay. Now, I'd just like to ask you some questions about LinkedIn's policies. I think I've seen a set of policies that's referred to as either the community guidelines or professional community policies. Are you aware of those descriptors?
The professional community policies are our external facing content policies.
Okay. And what are the community guidelines?
I'm not sure what that's a reference to.
So if I were to go onto the LinkedIn website at the moment and look at the bottom of the page in Australia, I would see a tab called Community Guidelines at the bottom that would link me through to the professional community policies. Is that consistent with your understanding of how the website operates?
I'm not sure, but if it's linking through to we call them the PCPs, those are the global external facing content policies. So I'm not sure about that tab.
Certainly. So they're the group of policies that effectively regulates user behaviour on the LinkedIn platform. Is that right?
That's correct.
Okay. Now, 3 of the core principles of those policies are to be safe, be trustworthy, and be professional. Is that correct?
Yes.
I might just take you to one of the policies, which is the harassment and abusive content policy. So I'll ask the operator to call up lin.0001.002.004. And to zoom in under the heading, I think that's sufficiently zoomed. So you'll see at the top that there's a statement that as a professional network, LinkedIn maintains a high standard for safe and civil conversations between members. Our policies prohibit a wide range of actions and behaviours associated with harassment, bullying, or other abusive conduct. Does LinkedIn have established policies or meanings that it attributes to those three concepts?
Yes, but I need to just explain one thing first. What we're looking at here is not actually the professional community policies. So this is more detail that's linked into those policies, just to make sure we're getting the descriptions right. On your question, yes. So the way we do this is we have external facing policies. Again, I'll call them the PCPs, the professional community policies. They are the main source of policy information for members. Within that document, they can link or they can click links that will take them to articles like this that provide more details about what we mean. And that's throughout the PCPs. On your question about harassment, bullying, and other abusive conduct, I think you're asking, do we then have internal policies that operationalize that? The answer is yes.
Okay. And you referred to this document a moment ago as an article. Is this document part of the PCPs or is it something else?
Yes.
Okay.
Yes, it is. It incorporated by reference.
Okay. Understood. Now, just focusing on the examples of harassment and abusive content, if you go down 1, 2, 3, 4, 5 dot points, you'll see that there's a reference to doxing or sharing personal information about others. What does LinkedIn understand doxing to mean?
I'm sharing confidential information about other people.
Okay. Now, 2 dot points down, there's a dot point that refers to comparing people or groups to Nazis, hate or extremist groups, or sexual predators. Do you see that dot point?
Yes.
And then in the final dot point, calling for social or political exclusion, deportation, or banishment of any individual or group because of their political or other non-inherent beliefs or affiliation. Do you see that dot point?
Yes.
Now, these examples of harassment or abusive content don't refer in terms to anti-Semitism. Is there a reason why LinkedIn has adopted that particular approach with respect to harassment and abusive content?
No.
Okay. So no deliberate policy decision has been taken to not pursue a definition of anti-Semitism in the context of harassment and abusive content?
To my knowledge, there was no intentional decision to affirmatively exclude that from this policy.
Okay. And if I could finally direct your attention to the very bottom of the page where there's a further hyperlink to hateful and derogatory content policies. Do you see that?
Yes.
Is that policy itself incorporated by reference into the PCPs?
Yes. It's a similar, I believe if you click that, it would take you to the hateful and derogatory content policy version of the page we're looking at now.
Okay. I might go to that policy next then. So if I could ask the operator to call up lin.0001.002.0023, which is a copy of LinkedIn's hateful and derogatory content policy, and to zoom into the relevant passage. You'll see at the top of the page that there's a reference to hate speech symbols and groups are prohibited on LinkedIn. We remove content that attacks, denigrates, intimidates, dehumanises, incites, or threatens hatred, violence, prejudicial or discriminatory action against individuals or groups because of their actual or perceived race, ethnicity, national origin, caste, gender, gender identity, sexual orientation, religious affiliation, or disability status. Do you see that?
Do you mind zooming in just for like one more click? I'm
Certainly.
a little bit far from the
We can
screen,
have the
even though
operator
I'm-
crop in on the top paragraph on the page. If it's is that better, Mr. Corrigan?
But I just want to make sure I see it. Yes, ultimately, yes, I understand what you've read.
And how is it that LinkedIn goes about identifying protected attributes for the purposes of articulating them in this policy?
But I don't recall how that was done originally. This is quite established at this point.
Mm-hmm. Is the list of protected attributes reviewed from time to time?
By the policy team, yes.
How often does that review process take place?
I'm not sure.
Okay. Now, just dealing with the examples that are identified underneath the bold heading, the first dot point refers to slurs and pejoratives used to demean others based on the basis of their inherent traits, promoting or expressing support for hate groups or ideology via symbols or otherwise, expressions of disgust towards or superiority over people or groups on the basis of inherent traits. A little further down, negative stereotypes rooted in inherent traits that reinforce harmful attitudes or behaviours against individuals or groups. And then in the penultimate dot point, Holocaust denial or misappropriation of Holocaust symbology. Is there any reason why anti-Semitism isn't dealt with in terms as its own distinct form of hateful or derogatory content?
No, I don't think there was an intentional reason to exclude. I think certainly drafters had in mind that all types of religious discrimination and bigotry would be covered by the words there. But the answer to your question is no, there wasn't an intentional decision to exclude that.
Okay. Now, the penultimate dot point refers to Holocaust denial or misappropriation of Holocaust symbology. What do you understand to mean by misappropriation of Holocaust symbology in that context?
Oh, that's a good question. I'm not sure. That's something that a policy expert would need to explain to me.
Certainly. Now, we've heard some evidence from some other platforms, including Meta and TikTok, that they've taken a position that references to Zionists or Zionist, when used as slurs or as a proxy for Jewish people, a violative conduct, in effect. Is that an issue that LinkedIn itself has grappled with or taken a policy decision on?
Yes, that is. Sorry.
No, please go ahead. I inadvertently cut you off.
Using Zionist or Zionism as a proxy in hateful content for someone who's Jewish or the Jewish religion is a violation of our policies in the same way.
Okay, but that policy stance isn't reflected in terms in the two policies that I've just taken you to. Is that correct?
We don't explicitly call it out.
But it's a policy that's applied by LinkedIn in its guidance. Is that the correct position?
Correct.
Okay. Now, LinkedIn doesn't track a subset of specifically anti-Semitic content that violates its hateful and derogatory content or harassment and abusive content policies. Is that right?
Doesn't track a specific subset of, do you mean, do we track subcategories of hate speech like anti-Semitic content?
Yes.
We do not track that. We don't track and report that, no.
Okay, and as a result of that absence of tracking it at the level of anti-Semitic conduct, for example, you're not able to provide data on the prevalence of anti-Semitism on the LinkedIn platform. Is that correct?
We don't have tracking data of subcategories of policy violations, which would include anti-Semitic content. That's across the board, yes.
Okay. Now, I'd just like to ask you some questions about LinkedIn's content moderation practices and removal rates. So if I could start by asking you about paragraph 40 of your statement, where you say that LinkedIn's policies are supported by product and design choices that aim to reduce friction in reporting of harmful content. Do you recall giving that evidence?
Yes.
Could you just explain what the product and design choices that you're referring to there are?
Yes, at a high level, what we're trying to do is make it as easy as possible for members to report content that they believe is abusive or violative of our policies. As little friction as possible, because our goal is to keep all of that off the platform. And so, so to answer your question, the choices made in where to put the reporting button, how the menu looks, how the flow operates, and things like that are made with ease of use in mind.
Okay. And there's a reference there to limiting the visibility of potentially violative material. Do you see that reference?
Let me just read it. Yes.
What do you mean by that? Is that a situation where the violative content is hidden for all users or just some users?
So a couple of things. I think what this is getting at is, and it's been a while since we drafted it, so I'm sorry, but this is more like the whole overall idea, as I said, is we want this stuff off the platform. We don't want people to see it. Separate, it is true that if a member reports an item of content for a violation, after they report it, they won't see it on their LinkedIn feed anymore. Though we do provide a feedback loop, so they will know what happened to that report. If it's, just to finish the point, if the report is confirmed as a policy violation, then it'll be removed the content will be removed, and only the author would be able to see it going forward. They would, and the way they would do that is by going to their profile to see it.
So in that scenario, in the period between the report and the determination of the report, does the post remain visible for other users aside from the reporter?
Yes.
Now, just in terms of that practice, I just want to ask you some questions about the effect of that. Does that convey to the person who reported that the post has been disabled from view to the public at large?
I don't think so.
Well, if they report the post and it no longer is visible for them, could a reasonable person in that scenario form the view that the report has been effective in removing the post from the platform?
Oh, I see. We don't tell the member that, we actually say, I think we say, you won't see this post anymore. We don't tell them that nobody else will see this post anymore. There's a bunch of language about how we will keep them in the loop on what happens to the report. Could somebody interpret that as meaning nobody can see it after I click report? Potentially, I guess. I'm not sure. That's not, my understanding is that's not super consistent with how platforms operate. So I'd be a little surprised if somebody thought that, but sure, it's possible.
Okay, and focusing on the person who made the post, if it's found that their post is violative and the post is not taken off their own manifestation of the LinkedIn platform, are they ever told that the post is violative?
Yes.
So they're told that the post is violative, but it remains visible for them on their feed. Is that your evidence?
Not their feed. Okay. So the way it works is if somebody reports it, the reporter will get a notice that says, thanks for your report. And then when a decision is made, if the decision is to remove the content, the reporter will get another notice that says we've removed the content. And the author will get a notice that says we've removed the content. Only you can see it. I think we might tell them exactly where, which is it's not on their feed. It's when you go to your own profile and look at the content you posted. And I think there's even a little notification there that says it's been removed from the public feed. But back to the notice to the author will also be told that they can appeal and the process for that. So there's no doubt in the author's mind, or there shouldn't be, that the content was removed.
Now, I just want to ask you some questions about the three-layered protection model that you address at paragraph 20 of your statement.
Sure.
And as I understand it, the first layer of that protection model involves automatic prevention. And you give some evidence about that at paragraph 20A. Could you elaborate on the specific automatic prevention methods that LinkedIn uses?
Sure. Models will run looking for harmful content, and if it's detected, I think it kind of depends on the type of content at issue, it'll be removed. So when I'm breaking down the type of content at issue part, some forms of content can be prevented even from being created on the platform. Others may go on the platform, but systems are running and they detect it, and it can be removed by this first layer.
And in terms of the specific methods that are used, do you use classifiers or large language model based automation?
So I'm not an engineer, and I could get the technology wrong. The way I think of them, or I speak of them, yes, as classifiers, models. LLMs are increasingly starting to be used, but that's the newer technology. The historical things we've been working with for years and years, I refer to as classifiers and models.
And does LinkedIn adopt hash matching as one method of detecting violative content?
In certain contexts, yes.
Okay. Now, the second layer that's referred to in subparagraph B is automated and human-led detection. Could you elaborate a little further on the circumstances in which that particular method is used?
Sure. So it's similar to the first layer insofar as the technology is running looking for harmful content, classifiers models, here again increasingly LLMs. But it's a situation where the technology, we don't have enough confidence yet in those systems to make decisions themselves. So they're sent to, the technology will flag an item of content, and then that is sent to a human for review, and then the human confirms whether or not it's a violation.
And in what proportion of cases, roughly, does that occur? Is it all cases that get referred to human moderation, or just some?
I don't have the proportions, but there are some that will get removed via the first layer. That's the concept we're trying to impart with the first layer, is the technology takes action, human involvement not needed. Second layer is the two working together, technology flagging something, and then the human making the determination.
And then in the third scenario, where it's human-led detection, is that the process that's applied where a user flags content?
Yes, that's a major part of it. We also separately have investigations teams that will do that. They're not out there just like patrolling the platform looking for things necessarily, but there are situations where a investigations team will get leads from other peer companies or somewhere else. They'll go and investigate and take action, but it's still purely human based is the point there.
Certainly. And in terms of the humans that are involved at the second and third layer, are they I think approximately 180 trust and safety staff and 1,500 contractors that you referred to earlier?
So yes, for most of it. So they're the ones that are looking at the member flagged content. And then it's not that's 90% of it, then there's a separate investigations and kind of other internal teams that can take action too.
And presumably the automatic prevention element of these processes is an area that's developing rapidly, is that correct?
Frankly, it's all developing quite rapidly, but that is part of it for sure.
Have any changes in the automatic prevention processes resulted in changes in staff numbers for human detection?
I'm not sure.
Okay. Now, I'd just like to ask you some questions about the content removal data that LinkedIn has provided. So if I could ask the operator to call up the spreadsheet at lin.001.009.0067. And to go to the tab at the bottom, 1B and 7 removals, and to line 125. Now, I just want to understand this data a little more. So in the label month column at row 125, there's a reference to 2025-01-01. Do you see that?
Yes.
What I want to understand is whether the figure in that column represents removals for hate speech in the month of January 2025.
I assume that's what it's saying, and my assumption is for Australia specifically, but I'm not, I didn't create this document, so I'm not completely sure.
Okay. So it's not a document that you had an involvement in preparing or collating, is that right?
No direct involvement, sure. My assumption is this was prepared in response to the document requests, and so that's why I'm assuming it's Australia specific, and I think you're right about the date. It's just I didn't put it together, so I'm not 1,000% sure is all.
But, I mean, focusing on the number 76 for hate speech removals, does it sound about right that LinkedIn is removing 76 items of content a month for hate speech, or does that number seem a little low to you?
It doesn't seem low. If we're talking about Australia, that wouldn't surprise me.
Okay. Why is that?
Oh, just my years of experience and in volumes and stuff. And I think if we're talking about a specific country, Australia, doesn't surprise me. Could be wrong. It doesn't surprise me. It doesn't shock me.
So for LinkedIn as a platform that has 17 million users in Australia, five pieces of hate speech content removed per day is not a surprising number.
No.
Okay. Now, I just want to ask you some questions about paragraph 41 of your statement, where you refer to the maintenance of policies that prohibit attacks against individuals or groups based on protected characteristics. I think they're the policies that we went through before. Is that right?
All right. Can I just have a second to read it? Okay. What was your question?
So my question is just about the first question was, when you're referring to the policies that prohibit attacks against individuals and groups based on protected characteristics, are you referring to the policies that we discussed a little earlier today?
If I recall correctly, we talked about the hate speech policy and the harassment policy, which would be two of them. There are other policies that would fit this bill, like threats of violence, extreme violence, potentially others.
Certainly.
But same ballpark, yes, that makes sense.
Same ballpark. Now, in the third sentence, you say content that is identified as violating these policies is removed, and repeat or egregious violations may result in additional account level enforcement actions. Are you able to elaborate on what you mean by that?
Yes, it can result in account restriction. It can result in what we call feature gating.
And what as far as you're able to tell us in this public forum, what is that concept referring to?
The latter one, feature gating, is when if someone has violated the policy enough times, doing a specific thing, like for example, posting content. Depending on the policy, at some point the penalty may be they are no longer able to post content, though their account isn't restricted wholesale. Though they're still able to apply for a job, read professionally relevant content and things like that.
And is there also an educative element to the response to violative content?
Yes, there's part of the process is what we call educational interventions.
Okay. Now, I'd just like to take you to two documents that are subject to some confidentiality restrictions. So I'll identify the document ID so that you can find it, and I think there'll be hard copies in the room,
yes,
but the document will not be displayed on the live stream. So the first of those documents has the document identifier LIN.00010.0010.0441. Do you have that document to hand?
Hold on, 0001.
.0010, and the final four digits are .0441.
Yes.
And you see that there's a heading in that document that is background. Do you see that?
Yes. Mm-hmm.
And you'll see that in the first sentence, there's a reference to what are termed strike thresholds. Do you see that?
Yes.
And can you describe for me the process that LinkedIn undertook in determining what would be appropriate strike thresholds for its user base?
So this is a process that's primarily driven by our trust product and engineering team. So I'm not super steeped in it. But overall, there's testing, there's an evaluation of historical data to come up with hypotheses on what the right strike thresholds are for particular policy violations. The idea being some policy violate, or I should say, members that violate some policies are more likely to be able to be rehabilitated, meaning they make a mistake, they learn what the policy is going forward, otherwise learn that that's not appropriate behavior on LinkedIn, things like that. But not all policies are the same. For some policies, there's very little doubt that somebody is not very likely to be rehabilitated, and then the other end of the spectrum is, well, these are not. Sometimes they're borderline calls. Sometimes reviewers can even make mistakes. Like, more likely that education and time could result in them learning how to properly abide by the policies.
Okay. Now, LinkedIn is an entity that generates revenue from subscription products. Is that correct?
LinkedIn's primary revenue is through enterprise software sales. So the bulk of our revenue is from selling software services to the recruiting professionals, sales professionals. There is a subscription-based service, though, that members can subscribe to, yes.
And in terms of the enterprise sales, the value of LinkedIn's product is linked to the number of people that can be accessed by the recruitment professionals who subscribe. Would you agree with that statement?
No, that's a bit of an oversimplification. I think it's not just a raw numbers game, for lack of a better phrase. The value of our recruiting product is in having healthy, robust profiles that feed into the recruiting product. This similar version up for our sales solution product, and then the marketing solutions product, which I forgot to mention, doesn't really factor into that. But I think the thing I can't quite agree with is it's not just like, no matter how many members or no matter what, more members the better. Like, the point is a healthy ecosystem, and we're not just looking for growth at all costs.
I'm not suggesting that you're looking for growth at all costs. What I'm suggesting is that to some extent, the number of users on the platform will contribute to the value of the product from the perspective of someone who is buying an enterprise solution.
I think that's part of it, but if it's not correct that it doesn't matter what the quality of that profile is, if that makes sense. Like, it's not like there are profiles, for example, that are not very well built out. Maybe a profile photo, like no real details, like that's not very helpful. So it's a much more sophisticated ecosystem. And so again, I hesitate to adopt the idea that it's as simple as the more members there are, the better it is for the product, because that's not. It's just it's just a little bit too much of a simplification.
Okay. Now, I just want to direct your attention to the words that appear under the bold heading problem statement. Do you see those words?
Yes.
And there's a problem statement that focuses on effects for users. Is that a fair characterization of the problem statement?
In the first sentence?
Yes.
Yes, that is correct.
What I want to suggest to you is that another aspect of this problem that's being identified here is that the more users that are deplatformed based on the strike policy, the more there will be an impact on LinkedIn's revenue as well.
No, that's not correct. So this is a reference to LinkedIn's mission, which is to create economic opportunity for every member of the global workforce. And so what this is referring to is whenever a member is restricted, this is binary. If they're not able to be on the platform, it necessarily limits their ability to access economic opportunity. So that's a reference to the company's mission, not LinkedIn's economics.
I appreciate that that's what this says, but you'd accept that LinkedIn's a corporation and not a charity, correct?
Sure.
And there's an element of self-interest in preserving a high user base from LinkedIn's perspective. Is that correct?
Again, it's not that simple. So what's really important for LinkedIn is that the platform is safe, trusted, and professionals. We hear this all the time, and the data bears it out. If members don't feel safe or they don't trust the platform, they're not going to be on it. And so that's actually why this, part of why we created this new system is that we don't want to hinder economic opportunity. The company's mission is to create economic opportunity for every member of the global workforce. But at the same time, we can't just have anybody on the platform doing and behaving however they want because we're here to provide them economic opportunity. That doesn't work because all of the other members need to feel safe, need to enjoy the platform, need to not be exposed to harmful content. And so the solution there to be able to still allow people to apply for jobs if they've made a bunch of mistakes with violative content is to not allow them to put that content on the platform anymore, but still apply for a job, for example, if they need to. So the idea that it's again, just a numbers game, like however many members we can get on the platform, the better. It doesn't really factor into what's really core to our business model, because you're right, it is a business, we're not a charity, and that's that members feel safe and that they can trust the platform.
So can you categorically rule out that the number of deplatformed users under the new strike policy was a consideration in moving to the new strike policy?
The number of I certainly can do that from a revenue perspective. It had the revenue implications of restricted members had no bearing on this project, to my knowledge.
You say to your knowledge. To what extent were you involved in the process?
Deeply.
Okay. And you have no reason to believe that revenue was a consideration at all?
No.
Okay. Now, can the operator please... Oh, sorry.
Just before you move from this document, Mr. Sherman, can I just ask this, Mr. Corrigan, in terms of LinkedIn's policy to limiting access to its platform, you took into account what you describe as industry standards, is that right?
Yes, I believe there was benchmarking, which is to say, at some point, I believe, and then again, this is another one that's more on the product side, if that makes sense. I believe there's a determination that as far as platforms go, LinkedIn was a little behind in having this as a solution, which is to say people felt like, well, kind of to what I was getting at before, just restricting accounts for certain policies. Some policy violations warrant one strike, your account's restricted. But for the more, the other ones, or some of the other ones, there was a feeling that we were behind the other platforms in enabling this kind of more sophisticated solution that allows people to still use the product for good, but be prohibited from using it for the bad activity that they've done before. That's what that's a reference to.
And in terms of gauging the industry standard, LinkedIn had regard to Meta and X. Is that right?
I'm not sure what
I'm just looking at the document you have before you.
Oh, it says, yeah. I assume that those were in there. I assume there were others as well. Yeah.
Yes, thank you.
Now, if I could take you to another document that's in the same category as the previous document, in that it's a confidential one that will not be displayed on the screen. The document identifier is lin.001.003.001.
Okay, so the last four are 000,
0001.
000. Okay, 0001.003.001.
Yes, that's correct.
Okay, got it.
And it's a document that refers to a concept that you discussed a little earlier in your evidence. Do you recall that?
I don't remember what I discussed. This is talking about the strike thresholds, though. Yes.
Yes, and there's a section that refers to content policy dash or column strike thresholds. Do you see that part of the document?
The top line?
Yes, there's a table that appears under the heading content policy.
Yes. Yep. Mm-hmm.
And then there are a series of policies in the left-hand column. Do you see that?
Yes.
And in the last cell, there's a reference to a cell that says hate speech. Do you see that?
I see hate speech is about halfway down.
Yes. And there's a identification of, and I don't want to get into the numbers because they might involve some third-party bad actor risk, but the first position, previous strike thresholds, there's a particular number that results in a particular action.
Yes.
And then in the second column, there's another number that results in a different, the same action. Do you see that?
Yes.
And then in the third column, there's another number that results in a slightly different action.
Yes.
Would you accept that as a result of policy changes in 2025, LinkedIn relaxed its strike thresholds?
It did, some of them, yes.
And what was the reason for that change?
It was what we were discussing before about feature gating being the penalty instead of account restriction. It was in connection with that. And I'm sorry. Are you asking about the middle column and not the last one?
Well, there were two changes that were addressed in this document. That's correct.
Right. So the last one is what I was just going on about. The middle one, I believe, was part of the issue was for this policy in particular, and as we discussed, this is not the only policy that covers anti-Semitism, but for this one, we were seeing that it was one of those where mistakes were more likely being made by members and by reviewers, and the hypothesis was that if we allow educational intervention type events by LinkedIn and give members an opportunity to learn the policies and abide by them, that they might rehabilitate. To be clear, however, there was never a moment where this content wasn't removed. These are all, the discussion we're having is about an enforcement strategy that relates solely to user penalties, not whether or not the content is allowed on the platform.
Now, would you agree with the proposition from the perspective of LinkedIn Corporation that our business may be adversely affected if we are unable to attract and retain additional members who actively use our website? Is that a proposition that you'd accept?
Can you say it again?
Our business may be adversely affected if we are unable to attract and retain additional members who actively use our website.
That sounds like a general growth strategy. So that doesn't surprise me.
Okay, but it's your evidence that these changes to relax strike rates had nothing to do with retaining members who actively use LinkedIn's website. Is that your evidence?
These changes had absolutely nothing to do with revenue. I can tell you that.
Now, you referred in your answer before to the circumstance that mistakes were being made by reviewers. Did LinkedIn collect any data that showed the rate at which reviewers were making mistakes?
This is one where I don't have specific, like, firsthand knowledge, but I'd be surprised if we didn't have that data. So I'm going to say yes.
What was the nature of the mistakes that the reviewers were making?
Oh, this would just, and again, I'm speaking at a high level. I don't have specific examples in mind, but this is just the idea that there are very obvious forms of hate speech and forms of violative content. And then there are forms that aren't as obvious. And some of that is, there's a variety of reasons for that. Some of that is some users know how to walk, you know what I mean? Like walk the tightrope right between the line. Others are just challenging. I mean, there's all sorts of content and context. And so given all of that and the complexity of some of these decisions, human reviewers make mistakes. And when you have a platform like when you have a platform like LinkedIn that has a very high bar from a policy perspective, there's lots of rules. It's challenging for human reviewers, and they can make mistakes. And when they happen and we learn of them, we fix them. But that is the phenomenon.
Okay, now in terms of just a final question on or two on this document. Now, in the middle table, there's a reference to the revised strike threshold being approved on a particular date. Do you see that?
Yes.
And that's a date in January 2025, is that right?
It looks like it.
And in terms of the second set of strike thresholds that are addressed, are you aware of if and when those strike thresholds were implemented?
The third column?
Yeah.
I assume it was June 2025, but I'm not sure.
Okay. Now, I just want to take you to a document that is a compilation of graphs from LinkedIn's transparency report section of its website. So if I could ask for that document to be brought up, or the document ID to be provided. It might be rcd.599.001.0048. And I just want you to assume, for the purposes of the questions that I'm about to ask you, that these are graphs that appear on the LinkedIn website in a section dealing with transparency reports. Can you adopt that assumption for me?
Sure.
Now, the first graph deals with a period from July to December of 2023. Do you see that?
Okay.
And you see the number of removals for hateful or derogatory content is 26,141. Do you see that?
Yes.
Is that broadly consistent with your understanding of the level of material that was removed for hateful or derogatory content in around 2023?
I don't have any reason to believe that this transparency report is inaccurate. This would be for half of 2023, though, the July to December period, not the full year.
Certainly. And then if we could go to the next period, which is 2024 January to June, and cropping on that. And there's a reference there to a fairly similar number of 26,726 for violent and graphic, 105,000 and 105,903 for hateful or derogatory. Do you see that?
Yes.
And so hateful and derogatory is moving up the rankings in January to June 2024. Do you see that?
It rose that following period, yes.
And do you have any explanation for the increase in hateful or derogatory material on the LinkedIn platform in that period?
I don't have specific data, but the assumption is that given that that is the 6-month period that followed the October 7th attack and all of the online content that led to, that it has something to do with that.
Okay, and there's also an increase in harassment and abusive content. Do you see that from 200? From 230. I'll go back to the previous slide if that would.
I forget what the other one said. Okay, 231. Mm-hmm.
And then 246.
246. Okay, so yeah, it rose. It doesn't seem like it rose as much.
And then if we go to July to December 2024, removals remain level at about 97,490. Do you see that? Oh, sorry, 92,748.
I see that, yes.
And harassment and abusive is at 250,000.
I see that.
Now, that's the period to December 2024. You see that at the top?
Mm-hmm. Yes.
And then if we can go to the next slide. You'll see that there's been in the period from January to June 2025 a significant increase in the amount of harassment or abusive removals. Do you see that?
Yes.
Do you have any explanation for the significant spike in harassment or abusive removals in that period?
No, I may have at the time, but I don't recall.
Is it possible that it's connected to the change in strike rates?
I mean, I highly doubt it, given that volume, but it could be.
Okay. When you say you highly doubt it, given that volume, what do you mean?
Because my understanding is that the actual the volume of content impacted by that enforcement strategy is not very high.
Okay.
Overall, for example, the number of members that, when you look at the scale of the platform, the number of members that engage in abusive conduct is low. So that's why I'd be surprised, but to answer your question, I do not know.
But I think you've accepted that it's possible that it could have some relationship to the strike rates. Yes.
Certainly possible.
Okay. Now, just for completeness, I'll take you to the next slide, which shows a similar number for harassment or abusive in July to December. Do you see that?
Yes.
Now, I just want to finally ask you some questions about another confidential document which bears the number LIN.0001.008.0018.
Okay, I didn't retain all that. Can you?
Oh, sorry.
A little bit slower.
It's the last document I intend to take you to. It's LIN.0001.008, and the last 4 digits are 0018.
00. Okay.
And the document, and I don't think there's any difficulty with me providing a general description of what the document is, but it's some guidance that was issued internally after the 7th of October 2023. Do you see that?
Yes. Yes.
And there's a reference to it being urgent guidance. Do you see that?
I do.
And in the background, there's just an identification of the context for the document. Do you see that?
Yes.
And in the yellow box, there's some guidance that's given about the implementation of LinkedIn policies. Is that a correct characterization of what's occurring there?
Let me give me 1 minute so I can review. Yes. So sorry, can you just repeat the question? So I'm
I'm just
accurate.
asking whether the material that appears in the yellow section of the document is providing guidance on how to
Yes.
implement a particular policy. Is that correct?
Looks like it's implementing 3 policies, but yes, that is
Yeah.
correct.
Yes, indeed. And is this document something that's communicated to content moderators, or what is its purpose?
I believe this is the type of guidance we spoke of earlier, that will be sent. Well, actually, we were speaking of regional guidance, and this wouldn't be regional. This, I believe, is guidance that's prepared by the content policy team and distributed to the content moderators to assist in them making accurate decisions when they review.
Okay, now, in the 4th and 5th dot points, there's some references to some slogans, and then there's a section that deals with the treatment of the slogans from a policy perspective. Do you see that?
Yes.
To the extent that you're able to in this forum, could you provide an explanation as to the reasoning for the treatment of those 2 slogans in the way that's proposed?
I'm not sure. My hesitation is just the confidentiality piece.
Okay.
So I'm not all the way sure I can.
Look, that's fine. Maybe I can ask a question about the penultimate dot point, where
Okay.
there's a slightly different variation of the slogan. Do you see that?
Yeah.
And it's indicated
Yes.
that that's not a policy violation to say that thing.
It is, yeah.
Now, we've heard some evidence during the course of the hearings that people frequently change words or adopt slightly different phrases in order to avoid content moderation occurring on a post. Are you aware of that phenomenon?
Yes.
Is that something that you experience in your role? Have you seen that within LinkedIn?
Sure. Yes.
Is this an example of that phenomenon being categorised as something that is not a policy violation?
I'm not sure. It could be. I have not seen that. I didn't write this, and I have not seen that phrase before, but I understand the phenomenon you are referring to, which is a very, very difficult problem, as you know, and we endeavor to do our best on that. But to answer your question, it could be. I do not know.
Okay. If I could take you forward to page 0045 and ask you some questions about the material that appears in the cell that's numbered 2 in that document. Do you see that material?
Yes, if I can have a second to read it. Okay, understood.
Does that guidance remain in effect?
This does, as does a specific set of guidance on this exact issue. if that makes sense.
And what advice or analysis did LinkedIn base the distinction that's reflected in that cell on?
I don't
I mean,
quite follow that
did you undertake any analysis or obtain any expert advice before drawing the particular line that's been drawn in that box?
I'm not sure. So I'm concerned that this is an attempt to characterize this box number 2 as our complete policy on this issue, which it's not. We're very clear that the use of Zionism or Zionists or Israel as a proxy for being Jewish or the Jewish religion is a policy violation if it's used to attack and degrade. This is a small kind of subset of that overall policy that was issued as part of this guidance. I actually don't know if there's other parts of this document that cover the other parts, but to the extent that this is meant to characterize this as the complete picture of our policy on this issue, that I have to be clear that's incorrect.
Okay. But you've previously accepted that's not a public-facing policy, that the policy to which you're referring.
Correct.
So what
Yes.
is LinkedIn able to say what its line is on that particular issue publicly?
Yes.
And what is the line?
I just did. It's if Zionism, Zionists, Israel are used, if the context shows that those are being used as a proxy to attack, they're proxies for Jewish people being Jewish, that is a policy violation. Which policy depends on what is actually happening. It could be hate speech, it could be harassment, it could be threats of violence. But those are policy violations.
If that's the case, why not just include it in a policy so that the world can see what LinkedIn's position is?
Well, it is in a policy. I think what you mean is why don't we publish that? It's a fair question. I understand, and I'm sure you know, there are a couple of other platforms that do publish a lot more on sort of issue-specific policy issues. And, historically, our external policies are clear. They maybe on some issues don't go into that level of detail, but our internal policies are very clear and do go into that level of detail. And we haven't historically published things like that, but that's not a forever decision or conclusion, and it's something that we will continue to evaluate.
Commissioner, I don't have any further questions at this witness.
Yes. Mr.
I
Kaplan?
believe I have 10 minutes.
I have no questions, Commissioner.
Yes,
10
Mr.
minutes of
Bender.
questions with your leave, Commissioner.
I'm sorry?
10 minutes of questions with
10
your
minutes. Well, I think we'll proceed.
leave. Thank you. Mr. Corrigan, I appear for several Jewish community bodies here in Australia. Can I start by asking you some questions about the named identity feature of LinkedIn? One of the consequences of that is if somebody were to post hate speech online, there might be real-world consequences for that person. For example, there could be legal action taken against them, for example. Correct?
I'm not an expert on the laws around that. I think if you're asking the real identity requirement of LinkedIn could potentially identify somebody who's posting things that are illegal, for sure, yes.
And the professional nature of LinkedIn as a network means that often if somebody were to publish hate speech, it could have negative career consequences and negative reputational effects for them, correct?
I believe so.
So that places a natural disincentive to people who are posting on LinkedIn not to post hate speech by comparison to people who can post anonymously on other platforms. Do you agree?
I do.
Notwithstanding that natural disincentive, LinkedIn, to its credit, makes substantial investment in online safety. You mentioned there are 180 full-time employees. Looking at that issue, 1,500 contractual reviewers and automated systems that screen every piece of content within about 300 milliseconds. You agree that's what LinkedIn does, among other things?
Among other things, yes.
As a professional working in the area of digital safety, is it a matter of concern to you that the internet generally, not just LinkedIn, the internet generally has reached a point where even a named identity network operating in the professional space needs to undertake such considerable investment in online safety?
The question is, does that concern me?
Yes.
It's an interesting question. Yeah, it concerns me. I'm not, like, this is the business we're in and we're fully invested in it. Concern is, it's sort of a general term, but it's not great.
Can I ask you some questions next about the Trusted Flagger program and how it applies in LinkedIn? You've addressed that in paragraphs 68 to 71 primarily in your statement. You refer in those paragraphs to LinkedIn operating a Trusted Flagger program in the EU in accordance with Article 22 of the Digital Services Act. Under that Act, the status of Trusted Flagger is awarded by a Digital Services Coordinator of the relevant member state of the EU. That's right, isn't it?
I believe so, yes.
And I believe that there are at least 2 entities that have been awarded Trusted Flagger status by within the EU that focus on anti-Semitism, one of which occurred quite recently, about 3 weeks ago, in Ireland. Are you aware of that?
I am not.
But are you aware that there are at least 1 or 2 bodies that have been designated priority flaggers within the EU that focus on anti-Semitism?
I had not been aware that there were specific bodies focused on anti-Semitism that have been awarded that status, but that doesn't surprise me.
You've also given evidence elsewhere in your statement that there is some engagement with Trusted Flaggers in the UK. Is that right?
Yes.
The UK doesn't have within its legislative scheme a designation system by the government for Trusted Flaggers. That's right, isn't it?
Yeah,
I'm sorry.
sorry.
The UK, I'm not as steeped in the law that, I've seen folks that are, that could be correct.
You've said in paragraph 71 of your statement that if Australia were to establish a Trusted Flagger designation through legislation or another formal mechanism, LinkedIn would work with those entities to ensure that appropriately designated reports are prioritised and actioned expeditiously. Does that mean that LinkedIn doesn't have a present intention to nominate as a Trusted Flagger any Australian body relating to anti-Semitism or any other topic?
Oh, I think that that's an overstatement. What we're trying to convey is that our current relationships with Trusted Flaggers are essentially statutory. Point taken about the UK, I'm not all the way sure, but this is new for us. Under the DSA, we only still, we're a few years into the DSA, we only have a couple. So it's TBD whether or not the Trusted Flagger programs will actually enhance our ability. I mean, I'm optimistic that they can, but there's also a theory that the Trusted Flagger statutory requirements actually exist for platforms that don't have robust existing content moderation systems. And so all that is to say, we're just communicating here that it's very early stages for us with Trusted Flaggers. If it ends up being clearly something that we can leverage to enhance and it makes sense in Australia, we would not necessarily wait for it to be statutorily mandated, excuse me. But as of now, the point is simply we do it to comply with the law. And if it becomes a law in Australia, we comply with the law, so we would do it there too. That's all we're trying to communicate.
Is there any reason that you're aware of that LinkedIn would consider there to be some detriment in adopting trusted flaggers, provided that they were appropriately vetted?
I wouldn't call it a detriment, but there's just a programmatic element to it, and requires vetting. There's a lot to it, and if it's not clear that there's a delta to what we're already doing, it just I'm not all the way sure it makes sense. But I'm open. Like if there are opportunities to enhance our ability to keep the platform clean, we will invest in them for sure.
And does that mean that LinkedIn would be open to, for example, adopting as a trusted flagger an appropriate, reliable, vetted body that focused on anti-Semitism here in Australia?
Yes.
Thank you. Thank you, Commissioner.
Thank you, Mr. Bender. Mr. Lim?
There's no re-examination, Commissioner. Thank you.
Anything arising?
No, Commissioner.
Thank you very much for your cooperation, Mr. Corrigan. That completes your evidence. The Commission will now take the 15-minute morning adjournment.
Thank you.
Royal Commission on Anti-Semitism and Social Cohesion is now in session.
Yes.
Commissioner, before I call the next witness, I do propose to deal with another matter, so Ms O'Loughlin may wish to return to the body of the hearing room for
Yes,
a moment,
very
so
well.
we'll take a couple of minutes. Commissioner, I propose to tender some documents concerning social media platforms that have either not cooperated with the Commission or have cooperated in a manner that was insufficient having regard to the nature of the assistance that was sought.
Yes.
During the course of my opening submissions, I made reference that some platforms have simply failed to engage with the Commission. I also identified that one issue that would arise in this round of the hearings was the need for a regulatory regime that is robust enough to deal with companies that are at the extreme end of the spectrum in terms of their apparent disregard of the Australian regulatory environment and community expectations. The question that I identified for consideration is whether the E-Safety Commissioner or some other regulator should be given greater powers to regulate the operations of all social media platforms, including the many platforms that are based offshore. There are a number of entities that have simply refused to assist the Commission at all with its work, despite having significant numbers of end users in Australia, despite earning substantial advertising revenue from publishing content to Australian end users, and in the excuse me, and in the case of X, despite the fact that it has invoked Australian regulatory and court processes in order to advance its commercial interests. The evidence that the Commission has heard to date establishes that a number of these entities operate social media platforms that are amongst the most prolific publishers of anti-Semitic content. So, Commissioner, I tender the bundle of documents described as platform correspondence in 2 volumes, and I'll make brief submissions on some of those documents.
Yes,
now.
well, those 2 volumes will together be received as an exhibit, Mr Lancaster.
Thank you. The first entity that must be addressed is X Corp. X Corp featured prominently in the evidence of experts and regulators as a key perpetrator in the proliferation of anti-Semitic hate in the online environment. Can I address first the Commission's attempts to engage X Corp? On the 11th of May, the Commission sought to engage X Corp by writing to the solicitors who have acted for X Corp in their litigation in Australia against the E-Safety Commissioner on a number of occasions. Some of that litigation is ongoing. The correspondence is tendered as part of the bundle. On the same day, that is 11th of May, X Corp was put on notice through correspondence to the same law firm that the Commission would hear from Dr. Oberle as to the prevalence of online and social media platforms containing anti-Semitism, which of course referred to his findings specifically about anti-Semitic content on X. A copy of Dr. Oberle's first report was attached to that correspondence. A further letter was sent to X Corp's Australian solicitors on the 27th of May requesting informal engagement from X Corp. On the 10th of June, a further notification letter was sent to X Corp through its Australian solicitors. The same day, those solicitors sent an email that simply read, "Thank you for the email letter. I acknowledge receipt." On the 19th of June, a further letter was sent to the Legal Policy Office of X Corp in Bastrop in Texas by registered express post. Despite all those numerous attempts to obtain X Corp's engagement, X Corp has remained silent. The Commission has received a substantial body of evidence concerning X's function as a transmission route for anti-Semitism and online hate in Australia. By way of broad example, can I refer to just some of the evidence we've received? Dr. Andre Oberle from the Online Hate Prevention Institute observed that X has been difficult to work with for about a decade, and particularly since it was borne by Mr. Musk, who significantly downgraded its trust and safety function. Dr. Oberle has observed that it remains a major online contributor to online anti-Semitism, and has observed a marked rise in traditional anti-Semitism on the platform. Indeed, Dr. Obler was personally targeted on the platform. Ms. Tali Blickbau of the Door Foundation has methodically documented the hate experienced by the Australian Jewish community, including a number of witnesses who appeared before this commission, and included within the tender that I've made are reports prepared by the Door Foundation that identify in detail instances of anti-Semitic hate on X directed towards witnesses, particularly lived experience witnesses from the Jewish community who chose to give evidence to the Commission. Ms. Talor Cohen of Cyberwell, who provided a global perspective on trends in anti-Semitic hate, gave evidence that X continues to present significant policy and enforcement challenges, particularly regarding coded anti-Semitism, AI-generated content, and emerging narratives. She gives evidence that, along with YouTube, X continued to present the most significant challenges among the social media platforms monitored by her organisation. She observed that X's removal rate for anti-Semitic content declined from 54% in 2024 to just over 29% in 2026, making it the platform with the lowest removal rate. The evidence continued. Ms. Hannah Rose of the Institute for Strategic Dialogue gave evidence about analysis her organisation conducted that had surfaced 128 posts on X glorifying terrorist violence that had received over 16 million views. She noted that following the 2 October 2025 terrorist attack at Heaton Park Synagogue in Manchester, there was a 28% increase in anti-Semitic slurs on X. Dr. Matteo Vigani of the Tackling Hate Lab conducted large-scale analysis of online hate directed at both the Jewish and Muslim communities in Australia, which provided a large-scale analysis of hate against those communities over a number of years, drawing on more than 2 million posts. His reports document with cold empirical precision the significant spike in hate against both communities in the aftermath of October the 7th. Finally, and you might think most importantly, lived experience witnesses spoke to the same effect. Mr. Arsen Ostrovsky, Mr. Stephen Lowy, Mr. Joshua Burns, MP, each provided detailed evidence of anti-Semitic hate that has been published online on X against each of them. In Mr. Ostrovsky's case, Commissioner, you'll recall that hate included the vile material directed to him in the aftermath of the Bondi Hanukkah attack. In Mr. Lowy's case, the hate included material that's included threats to his safety and the safety of his family. In Mr. Burns' case, the hate disseminated through X has included material supporting attacks on his office, the venue of an elected representative, a place of work, a place adjacent to homes with families, a place where Australians seek to engage with their elected representative. X Corp has not responded to any of this. Although an apparent proponent of unconstrained speech, X has remained silent. In the course of its work, the Commission has also observed X Corp's corporate behaviour in its interactions with regulators and government. Ms. Vandenbroek from the Commonwealth Department was taken to a letter sent by X Corp to government opposing a digital duty of care to which no officer of the company was prepared to put his or her name. The E-Safety Commissioner has given evidence that X is amongst the most adversarial of her relationships with mainstream entities. The E-Safety Commissioner also gave evidence that there have been 8 cases between E-Safety and X Corp in the Federal Court or the Administrative Review Tribunal concerning the scope of E-Safety's powers, with 6 of them started by X. X has also challenged notices issued by the E-Safety Commissioner directed at obtaining basic information about its responses to terrorism and violent extremist material on its platform, a wider problem that is also identified in the materials provided by the Institute for Strategic Dialogue. X has demonstrated a complete lack of interest in providing transparency concerning a topic as important as keeping Australians safe from the proliferation of terrorist and violent extremist material, including extreme anti-Semitism. X Corp's attitude to regulation and to anti-Semitism is perhaps most evident in its response to footage connected with the Bondi Hanukkah attack itself. The E-Safety Commissioner gave evidence about the existence of a video of deceased persons at the scene immediately after the Bondi Hanukkah attack. The E-Safety Commissioner became aware of the video and it was refused classification under the Australian classification regime, which meant it could not be published. X Corp challenged the decision to refuse classification. The E-Safety Commissioner successfully defended the case at first instance, so the video cannot presently be shown. Now, bringing the proceedings to challenge the classification was a step that was legally open to X, but what does it say about corporate social responsibility? X Corp generates profits from content displayed on its platform and does so by promoting unconstrained publication of speech and images. X decides to be active in Australia, to fight for content to be available on X that would, if published, cause immense sadness and harm to the Australian Jewish community. Yet the same company refuses to engage with an Australian Royal Commission that is inquiring into ways to make social media a better place for Australian end users. It shows a shocking disrespect and disregard for the Australian community. The submissions that X Corp made in support of its application to reduce the classification rating should also be mentioned. It's not appropriate to display those submissions either in the hearing room or on the live stream. X supported its case by saying that notorious depictions of historic and political significance are available online, none of which have been refused classification. The submission attached page after page of images from the Holocaust. The submissions, I will tender the submissions. The access to the submissions you will determine at a subsequent time, Commissioner, but they bear the ID DTR.043.0001.0036. So I tender that in addition to the bundle, but as
Yes.
I've mentioned, access to that is
The
to be
submissions
determined.
will be received as an exhibit.
They are detailed submissions prepared on X Corp's behalf. It was extraordinary of X to deploy those images. In my submission, they give no support to a contention that a video made in 2025 showing some of the deceased after the Bondi Hanukkah attack should be permitted to be shown online, and the use of Holocaust imagery in that context should be unequivocally condemned. During the course of the E-Safety Commissioner's evidence, she referred to the concept of a social licence. X Corp's conduct, both within this commission and outside of it, begs the question whether X Corp has or ought to have a social licence to operate in Australia. And I mentioned some of the other platforms. Telegram has been identified in evidence as a platform that has a significant role in the spread of anti-Semitic content to Australian end users. Telegram does not have a local presence in Australia. No part of the corporate group is incorporated in Australia. So far as we are aware, there are no physical corporate offices maintained by Telegram in Australia. In circumstances where Telegram had no presence in Australia, the Commission's correspondence could only be sent as an assistance request. Nevertheless, correspondence was sent on the 27th of May, on the 19th of June, on the 26th of June. There are copies of that correspondence in the bundle. No response of any sort was received from Telegram. In respect of Reddit, on the 27th of May 2026, correspondence was sent to Reddit Australia by the Commission, including a letter enclosing a notice to produce and give a statement. On the 10th of June, Reddit provided a response to the notice. Reddit produced a corporate statement and some documents, but Reddit Inc., the overseas entity, declined to provide documents in response to many of the categories of information that were sought. Subsequent correspondence did not result in improvement to the quality of the response. Can I mention a couple of others? OpenAI, Twitch, and the Australian platform Kik. Those three entities warrant mention as they are entities that did provide the Commission with materials. The response was not comprehensive, but it did amount to what in my submission was a reasonable degree of cooperation. OpenAI provided a statement from Ms. Nora Puckett, an Associate General Counsel at OpenAI OpCo LLC, and that statement forms part of the tender. Twitch, one of its competitors and a subsidiary of Amazon, has produced documents to the Commission together with a response to the notice. The Commission has also received evidence, materials from the Australian platform Kik, and some of those materials that I've referred to from each of those platforms form part of the tender. I note that we heard evidence during the oral evidence of Ms. Lord from Google, an organisation that many Australians would regard as large, respectable and trusted, refused to furnish to the Commission information regarding decisions made overseas to reduce the number of content moderation staff. Commissioner, you'll also recall that when challenged on YouTube's decision not to remove content that labelled Mr. Ostrovsky a false flag actor, content that could not, on any rational reading of YouTube's own community guidelines, be regarded as anything other than violating them. Ms. Lord thanked the Commission for its feedback and indicated that a final decision had been made overseas with the scantest of reasoning or explanation provided. The fact that such a position could be taken by a large and reputable platform in the context of this Commission does speak to the urgency of appropriate regulation of social media platforms. Can I mention Snap? In respect of Snap, the Commission has received a statement from Mr. Ben Au, who is the Head of Public Policy for Australia and New Zealand at Snap Australia Proprietary Limited, an entity associated with the widely used app Snapchat. Without criticising him, there were challenges in arranging for him to give evidence during this hearing block, and the Commission will attempt to call his evidence at a later time. The Commission also provided a number of other platforms and online providers with notice of the Commission's work, and each of those platforms are the subject of evidence suggesting they carry online hate and anti-Semitic content. No specific materials were sought from these platforms, but they were notified of the proceedings of the Commission. They haven't sought to be heard. It's referred to in the bundle. They include Discord, Roblox, Steam, Substack, and Upscrolled. Can I mention, in respect of Upscrolled, there are documents in the tender bundle produced by entities associated with Google and with Apple concerning their handling of complaints about the Upscrolled app, which is an Australian app that has been identified in the evidence as a haven for anti-Semitic content. The responses of Google and Apple to that app and the complaints about it will be the subject of written submissions by counsel assisting, and each of those entities will be provided with an opportunity to respond to those submissions should they wish in due course. I've not exhausted reference to social media platforms in these submissions. These submissions have dealt with platforms that have not been examined by oral evidence taken from witnesses during the hearing block. Commissioner, you will of course recall that the Commission has, you have noted the participation of Anthropic and of TikTok, including by senior executives travelling to Australia for the purpose of appearing here, and the participation of Meta and Facebook by witnesses who appeared by AVL and in person, and by the participation of YouTube, who is represented in some respects by an officer of the local company of the corporate group, and as you heard earlier today, by a representative from LinkedIn who appeared by AVL. Now, the varying degrees of cooperation exhibited by social media platforms in relation to the work of this commission, which cover a wide spectrum from Anthropic to X Corp, itself raises important questions about the reach and effectiveness of Australian regulation of platforms and online providers. Plainly, what occurs on social media platforms like X and Facebook and YouTube and TikTok has profound consequences for Australians. The social media companies are not sufficiently addressing anti-Semitism online. Regulatory obligations must be imposed on them because they are not taking care of the problem themselves. If obligations are imposed on social media platforms, they must be capable of being enforced in Australia. If social media platforms are capable of inflicting harm or are actually inflicting harm upon Australians, the laws of Australia must be capable of securing accountability for those harms.
Yes. Thank you, Mr. Lancaster. It will not come as a surprise to those who are following the work of this commission that regulation of the online ecosystem in order to tackle hate speech and anti-Semitism in particular is very central to the work of this commission. Yes, Mr. Lancaster.
I call the next witness, Ms O'Loughlin.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes, thank you, Ms. O'Loughlin.
Ms O'Loughlin, please state your full name.
Nerida O'Loughlin.
Your address is known to the Commission and you have prepared a written statement dated 12 June 2026.
I have.
The contents of that statement true and correct?
They are.
Commissioner, I tender the statement. It has the ID STA.0138.0001.001.
Yes, the statement will be marked as an exhibit.
Ms O'Loughlin, the ACMA has also provided us a supplementary statement which is not provided by a particular officer. You're aware of that?
I am.
Do you adopt the contents of that statement as true and correct?
I do.
Thank you. You're appointed, Commissioner, I should tender that before I move on. It is ACM.999.001.001_R.
Yes, the supplementary statement adopted by Ms O'Loughlin will be also marked as an exhibit.
You're appointed Chair and Agency Head of the ACMA on 14 October 2017.
That's correct.
You're reappointed to that role in 2022 and 2024.
That's correct.
Your current term ends in October 2027.
That's correct.
Prior to taking on your current role, you were a Deputy Secretary in the Commonwealth Department of Communications.
I was.
You have also served previously as CEO of the Digital Transformation Agency.
I did.
And since April 2019, you've also held the position of a part-time associate member of the ACCC.
That's correct.
The ACMA is responsible for regulating broadcasting, radio communications and telecommunications in Australia.
That's correct.
It also has regulatory functions with respect to some aspects of online content, gambling services and spam communications.
That's correct.
It's comprised of yourself as Chair, a Deputy Chair, 2 other full-time members and 2 associate members.
That's correct.
And does that group have other staff and assistants?
It's supported by around about 400 staff.
Yes. The ACMA has a number of regulatory powers and functions that are potentially relevant to anti-Semitic and other hateful content, is that right?
That's correct.
At a high level, the ACMA has the power and functions that are directed in ensuring that broadcast content is compliant with the Commonwealth Broadcasting Services Act.
That's correct.
And for licensed broadcasters, that includes ensuring broadcasters are compliant with licence condition imposed on them.
Correct?
And it includes ensuring that licensed broadcasters comply with standards made by the ACMA.
They are compelled to comply with industry codes of practice
Yes.
or any standards made by the ACMA.
Yes. Now, can I just ask you about the differences between arrangements in a regulatory sense between public and other broadcasters? So the ACMA's powers and functions with respect to commercial, community and subscription services are different than those with respect to public broadcasters.
That's correct.
Could you encapsulate the different scope of your powers?
Of course. So, as you mentioned, our powers derive from the Broadcasting Services Act 1992. That Act covers a range of responsibilities from things like anti-siphoning regimes, prominence regimes, licensing, media and control. It does not extend to the online services of broadcasters. It also does not extend to print media, nor does it extend to online platforms. For content within those, as you mentioned, our main responsibilities are twofold. Around codes of practice, which mainly drive the way that broadcasters comply with the law, and also our role in complaints and investigations of potential breaches of those codes of practice. So, and the role reflects from 1992 the intention of the Parliament that broadcasters would have a greater role in dealing directly with complaints themselves and managing those complaints, and also managing the content regulation to respond to the audience's requirements. In terms of the different roles, which are quite different under the law, in terms of licensed broadcasters, which as you mentioned cover commercial broadcasters, community broadcasters and subscription broadcasters, we register the codes of practice. So the codes of practice are developed by industry groups representing those broadcasters. They come to the ACMA, and under the Broadcasting Services Act, we must register those codes if we consider that they contain appropriate community safeguards, which is the test that's set down in the statute. So we may have an interaction with those broadcasters about where we think their draft codes may be lacking, and we can only accept that code where we think that it does provide appropriate community safeguards. In that regard, we've recently rejected a draft code proposed to us by Free TV Australia, which represents the commercial broadcasting industry, because we did not consider that it provided appropriate community safeguards around alcohol advertising. So we do have a strong role there. In terms of the national broadcasters, they are, under the statute, develop their own codes. They do not need to be accepted by the ACMA, and they will advise us of changes to their codes and put those codes in place. Similarly, we have slightly different roles in terms of investigation and breaches of those codes. Where we look at commercial broadcasting, subscription and community, we have powers to agree measures. So if we find a breach, we can agree measures for improvement for future compliance from those broadcasters. We can also seek court enforceable undertakings from broadcasters, and in extreme circumstances we can also impose additional licence conditions. As licensed broadcasters, there's a range of licence conditions to which they're subject, along with those codes of practice. We've recently imposed an additional licence condition on the commercial broadcasters responsible for the Kyle and Jackie O program, for example. With the national broadcasters, as I mentioned, they develop their own codes. If we find breaches of those codes, our powers are somewhat less extensive. We can really only agree measures with the ABC. So come to an agreement on what they might do to ensure future compliance where we've found breaches of the code. That may involve them removing content. It may involve them doing additional training on our decisions to inform their future compliance. So they're the main difference between the two regulatory regimes.
Thank you. And your reference to national broadcasters, of course, is to the ABC and
To
SBS.
the ABC and SBS, yes.
You have used the expression a co-regulatory system to describe the regulation of broadcast content. Is that the way you would characterise both the licensed broadcasters and the national broadcasters, or?
They are both designed as co-regulatory schemes, and as I mentioned, that the establishment of the 1992 Act moved content regulation away from a much more interventionist regime which existed beforehand. It really wanted to make sure that broadcasters would respond to their audiences themselves and have the opportunity to respond to any complaints prior to it coming to the regulator. So in both, for licensed broadcasters, ABC and SBS, they have the opportunity to respond to complaints directly to audience members, and then if the complainant is unsatisfied with the response from the broadcaster, only then can they come to the ACMA for codes of practice breaches.
You've referred in your statement to a desire for broadcasting services to be regulated so that public interest considerations are addressed in a manner that does not impose unnecessary financial or administrative burdens.
That's
what do you mean
correct.
by
That's
that?
actually within the statute in the Broadcasters Services Act 1992.
Yep.
So that was also a feature of the changes of the law in 1992, was to reduce costs to the broadcasters, but also make sure that in doing so they were held responsible for their content.
As compared to the alternative, which is requiring a regulator to take on the financial or administrative burden, as the statute refers to it, of doing all that
Exactly,
itself.
and also allowing the broadcasters to be responsible for their own processes and systems to provide efficient complaint handling processes.
You've mentioned that the codes of practice apply across the industry, but there are industry codes of practice and also national broadcasting services codes of practice.
And they're quite different, each of them, so each industry group has a different code.
Yes. Turning to national broadcasters, I think you've mentioned ACMA's remit is limited to content broadcast on terrestrial television and radio services.
That's correct.
So if I could go to your statement at paragraph 26, please. You've described in that paragraph that the ACMA has no relevant role in relation to the Australian print media, such as newspapers or magazines, or content published online, such as news websites, blogs, or social media posts.
That's correct.
Now, the content published online that you refer to there includes news websites?
Yes, indeed.
Yeah. So ACMA does have regulatory functions in respect of, for example, ABC News that is broadcast on TV, but it doesn't have regulatory functions in respect of ABC News published on the ABC website.
That's correct. And print media generally, including news websites, is subject to a self-regulatory regime, and that's oversighted by the by the Australian Press Council.
That different treatment of the example I picked was ABC News, but that different treatment according to whether it's on TV or on the website seems a bizarre limitation on ACMA's functions in 2026.
It certainly presents some challenges to us, and I think it also presents some challenges to complainants. We've had a range of complaints come to us over the last few years, which have been out of our jurisdiction, so which must be very frustrating for a complainant when they're proposing to complain about something which is broadcast on the ABC where they can come to us, but we've had to go back to them to say that because that was on a podcast or it was delivered through WhatsApp or it was on a website, it's out of our jurisdiction.
Yeah. Have efforts been made to review the scope of ACMA's powers and functions in respect of content published online, on websites or on social media?
We've had, over time, various discussions around what would be the right regulatory framework for the future. I would give acknowledgement, though, to SBS, their code of practice. They voluntarily extended it to their BVOD services. So they're those services which are either SBS On Demand or the online version of their broadcasting services. So they've done that voluntarily. We requested that the commercial broadcasters also agreed to voluntarily extend their codes of practice to those services. To date, they have not agreed to do so.
You referred to the challenges, was your word, that are involved with that distinction between ACMA's powers and functions across different methods of delivery of the same content. Could you describe what those challenges are in brief?
Certainly. I think it's actually a challenge also for audiences. So when we occasionally get complaints from people who may have seen something on their television and they come to us to complain about it. And when we look into it, it was actually a streamed version of a television program. So it wasn't delivered over terrestrial spectrum, it was streamed online. It's the same content, and yet we can only take action if it's delivered through the broadcasting services bands. We can't take action elsewhere. I think that's very confusing for audiences in this day and age. I think also that the rules that are applied to broadcasting services that are now more and more delivered online should be the same.
You've referred to the functions of the Safety Commissioner.
Yes.
And she has regulatory responsibility for certain aspects of the content on online platforms.
Indeed.
Yeah, but it's by no means a comprehensive review or regulatory power. You agree?
Yep.
You in paragraph 26 in the final sentence refer to the situation as being that print publications and online media content is primarily dealt with under self-regulatory arrangements, including the Australian Press Council.
Yes. So the Australian Press Council develops its own guidance for, and there are also, of course, journalism codes themselves. So the Press Council develops that guidance, which print media organisations, most of them, not all of them, sign up to, and then the Press Council will be responsible for investigating any complaints of concern and making any judgment against those rules.
Yes, thank you. Can I ask you about industry codes of practice? Now, these are capable of applying to a wide range of types of services, commercial and community broadcasters, subscription broadcasting, and the providers of subscription and open narrowcasting services.
That's correct.
ACMA does play a consultative or advisory role with respect to the development of codes of that sort?
We do, and in a couple of ways. And firstly, we share transparently the outcomes of all our investigations, so that gives industry a sense of where we're looking at matters of concern. We also undertake research from time to time around what we're seeing as being broader audience concerns. The last of that was done in 2022. We did a very big research piece called What Audiences Want, which really looked into what are the expectations of audiences of television and radio services today, be that fairness, be that accuracy, impartiality, be that disturbing content. And that is, we made that all available to the broadcasters, the licensed broadcasters, as they update their codes of practice, so they have a very clear understanding of what the regulator is seeing, and we ask them to respond to that.
And the engagement goes to the extent of suggesting drafting suggestions, making recommendations for improvements to draft codes and
We
so on.
do. We have a intense dialogue, shall we say, with those licensed broadcasters about our expectations. As I mentioned, we recently rejected the free TV code because of our concerns, but we also recently accepted a new code from Commercial Radio Australia, which extended some of their rules around radio broadcasting in direct response to the issues that the ACMA raised with it.
Thank you. Can I ask you about an ACMA document called What Audiences Want, which of course you're very familiar with, but can I go to rcd.599.0001.0033? While it's coming up, can I ask, this is intended to provide guidance to broadcasters on contemporary audience expectations in Australia?
That was the intent. We're at a time in June 2022 when there are a range of codes up for updating. We weren't clear on when the broadcasting industry would move to undertake that work, but there are a number that were, in our view, quite well out of date. So we thought to inform the development of codes across the board, be that commercial, television, radio, subscription, or indeed the ABC and SBS, it would be useful for us to bring together the research we've done, the outcomes of our many investigations over a period of time, and to present something to industry which was comprehensive in terms of what we thought audiences were expecting from them.
The first page of the documents come up and it refers in its subheading to being a position paper for professional content providers. Is this limited to, is the intended application of this limited to licensed broadcasters or to all broadcasters? It
was intended to be considered by all broadcasters.
Now, when ACMA undertakes its statutory functions in relation to consulting and advising on code development and review, this document, I take it, since its publication, plays a central role in that.
Absolutely, and I think some of the areas that we wanted to just remind broadcasters about how important they are for audiences were in the areas of things like accuracy and impartiality, commercial interests, of making sure people know when there are commercial interests sitting perhaps behind a program, emergency information, distressing and high impact content where there may be the broadcast, just flagging with the broadcasters, but that before they put things to air, they really need to consider whether that content is going to be distressing, and other areas such as highly offensive and discriminatory material.
Okay, can I take you to that aspect of the document? It's on page _0011. And in the graphic, that sets out two broad categories of audience expectations.
That's correct.
And one of those is the one you've just mentioned in respect of general content. There's an audience expectation about, or assuming the absence of highly offensive and discriminatory material.
That's correct, yes.
And that's given some further detail at the page I'll go to now, _0030. And the top of the page, ACMA sets out that audiences expect that highly offensive or discriminatory material that's unsuitable for general dissemination will not be made available by content providers except in limited circumstances where it's justified by the context and has appropriate warning measures in place.
Indeed, and I think what we were flagging at that point is that there may be, in some limited circumstances, an important public interest need for some material to be exposed. But in the main, that the audience's expectation is that that type of content would be unsuitable on the airwaves.
And in the first paragraph under the heading Overview on this page, the document refers to safeguards that address matters such as discrimination and inciting hatred, and the document goes on to include in that description inciting or perpetuating hatred against or vilifying any person or group on the basis of ethnicity, nationality, race, gender, sexual orientation, age, religion or disability.
And that phrasing is in the main also reflected in the licensed broadcasters' codes of practice. It's got slightly different wording, in the ABC code of practice under harm and offence, but that's in many respects directed to the same area of content concern.
And then over the page at underscored 0031, the document has a heading Contemporary and Emerging Issues. The first paragraph under that heading refers to the fact that many broadcasting codes set a threshold of intense dislike, serious contempt or severe ridicule for the objectionable material.
That's correct. They actually, in most of those codes, set a reasonably high bar.
Yeah, which generally might reflect anti-discrimination legislation and its expression.
Indeed.
And then the final of the 4 points that's highlighted on the screen refers to hate speech and highly offensive content, and makes the observation that community standards in this area can change relatively quickly.
Indeed.
Yeah. Can I just ask you about that? This document was prepared, I think, in June 2022. Has it gone through a process of updating, or is it intended to?
It hasn't been through a process of updating. It is, I agree, a point in time. It is something that we made available. As I mentioned, it was a time when a number of codes were up for being updated. I would expect that it was an exceptionally useful document for us to undertake, and I think it will be something that we will continue to update over time.
At the moment, if the ACMA is considering the contents of a code of practice, this is the document that it would have regard to?
It would also have regard to, the document doesn't constrain what we have regard to. We may take that research into account, but of course we would also have our experience and investigation and outcomes of any investigations that have been done since this time, which may reflect different community views than what were reflected in the paper of June 2022.
It certainly couldn't be denied that in the period between mid-2022 and now, community expectations in respect of, for example, news reports of the Middle East conflict are something that have changed and become much more prominent in the community.
And I agree with that, and that would be reflected in our investigations, and our outcomes of our investigations since that time would take into account that very important context.
You agree that if this document were being rewritten now, the contemporary issues could appropriately include a specific recognition of community expectations in respect of the absence of hate speech that's either anti-Semitic or Islamophobic?
I agree with that.
Now, dealing with the industry codes, the ACMA does have power to amend a code that's been registered under the Broadcasting Services Act?
We cannot amend a code without a quite lengthy process. Sorry, I'll go back a step. We can request amendments to the code, but we can't amend the code ourselves.
I see.
So the pathway for our intervention at that point would be to find that a code was deficient, and to start a process of developing a regulatory standard.
You've referred to the fact that industry groups, in ACMA's view, must take into account community attitudes regarding the portrayal in programs of matter that's likely to incite or perpetuate hatred against or vilification of persons in those protected categories I referred
Yes,
to.
we do.
Your statement also indicates that the ACMA does have power to determine standards for commercial TV and radio under the Act, where there's convincing evidence that the industry code is not operating to provide appropriate community safeguards.
That's correct. It's a power we have both under the Broadcasting Services Act. We also have a similar power under the Telecommunications Act. In the case of the latter, we have moved over the last 6 months to determine that one of the telecommunication main codes around consumer protections was deficient, and that we would move to develop a regulatory standard.
Are there examples of ACMA invoking that power in respect of anti-Semitism?
No, there's not.
Now, as you've mentioned, the national broadcasters develop their own codes of practice and then notify them to ACMA.
That's correct. That's the regulatory arrangements under the BSA.
And in respect of the development of the current ABC and SBS codes, was ACMA consulted in the course of that development?
I think our engagement with the national broadcasters was consistent with the regulatory framework. We had discussions through the development of each of their codes, but it was more in terms of them keeping us informed about the progress of the development of those codes and what they were intending to do, rather than any stronger engagement. So it was more an information sharing than a dialogue.
You've included in your statement some tables that are referred to in paragraph 43 that include extracts of the provisions of each of the codes to which the ACMA might refer in responding to complaints about anti-Semitism, or for that matter any other form of racism and discrimination in relation to content. Is that right?
Yes, that's correct.
And in relation to the ABC and SBS codes of conduct, the main provisions are the harm and offence provisions of their code?
A number of the complaints that have come to us, we've either looked at the harm and offence provisions, or in some areas we've looked at the accuracy and impartiality provisions in the ABC code, depending on what the complaint points to.
And the SBS code has that additional provision addressing prejudice, racism and discrimination.
That's correct.
You consider as relevant too?
Yes.
Now, neither of the codes contain provisions that explicitly identify a requirement to avoid or address anti-Semitism, but they do contain general provisions prescribing discriminatory or offensive material.
That's correct.
In your view, given what you know about the prevalence of anti-Semitism in modern times in Australia, ought consideration be given to those codes explicitly proscribing anti-Semitic material?
I think that we have been able to look at that type of content under the existing code provisions. That has not constrained us in looking at those. I think it would be a matter for the broadcasters themselves to consider whether or not specific provisions need to be put into their codes, or to assure themselves that this type of content can be dealt effectively under their codes of practice.
Can I ask you about the ACMA's complaints handling and investigative powers? So the ACMA does have a function of monitoring and investigating complaints concerning broadcasting services, including, of course, the national broadcasters.
Indeed, that's comprehensive.
And the ACMA can investigate compliance with codes of practice either on receipt of a complaint or on its own motion or at the direction of the Minister. Is that right?
That's correct, yes.
And where a person makes a complaint, the general response will be that you're required to have raised it with the broadcaster before ACMA will investigate it.
So in the general sense with codes of practice, the co-regulatory framework requires the complainant to raise it with the broadcaster, and then if they are unsatisfied with the broadcaster's response, then they can come directly to the ACMA.
Are there circumstances in which ACMA will respond to a complaint made directly to it?
We would normally, if a complainant comes directly to us and it's around a code of practice matter, we would advise the complainant to go to the broadcaster in the first instance, and then that the door remains open if they're unsatisfied to come to us. That's the way the regulatory framework works.
Yeah. And I mentioned that and you agreed the Minister may also direct that ACMA conduct an investigation.
The Minister has the power to direct us to undertake an investigation.
And has that power been exercised at all or frequently in the last, say, 5 years?
Not frequently. From memory, there's been a couple of times that ministers have directed us to undertake investigations around issues like anti-siphoning. I do remember one ministerial direction from some time ago now, where the Minister directed us to look at the around reality television, looking at concerns that have been raised at that time, and this is probably 10 or 30 years ago, around issues of concern around reality television in the broad, rather than necessarily individual complaints.
Now, without seeking to go to any confidential information regarding enforcement procedures, can I ask you about the approach that ACMA takes, which you refer to as a graduated and strategic risk-based approach to compliance and enforcement? That's your paragraph 84. Could you explain what that approach involves?
Certainly. So, in determining any enforcement action, firstly, as I mentioned earlier, in the broadcasting services, in the broadcasting space, we have quite a limited number of enforcement options available to us. So that's the context in which we consider enforcement. But where we would, what we would turn our mind to then would be the nature of the breach, the harm of the breach, whether or not this was the first time that a broadcaster might have been in breach of that particular code provision, or whether they were a repeat offender. So we would take all those into account in looking at what enforcement approach we would take. As I mentioned with the licensed broadcasters, often that is agreed measures. So it may be that the broadcasters commit to auditing of their processes and systems, or looking at additional staff training, or we have from time to time had agreed measures where additional sensors were applied to a program. So we would look at that. In circumstances where we think it is warranted and we need to escalate that action, we may seek court enforceable undertakings from the broadcaster, which is a very good and strong tool for us to use. And then the next leap up, I suppose, is for us to apply licence condition, which is quite a substantial intervention and one that is not used very regularly. But as I mentioned, we did take the approach last year of applying an additional licence condition to the broadcasters who carried the Kyle and Jackie O program.
Yes.
Beyond that, if there are additional breaches to licence conditions, then we have a very blunt power, which is the ability to suspend or cancel a licence, which in my memory has never been used.
And in relation to national broadcasters, is it fair to say the range of ACMA remedies is even more limited?
That's correct. It's limited to very much an agreed measures with the ABC. We can provide a notice to the ABC, but again, we can't compel them to take additional action, and we don't have available to us, for example, the enforceable undertakings power.
Yes, and the notice that ACMA can issue is a reflection of the power to recommend that the ABC or the SPS take
an action.
Specified action or do something with its code of practice, but that is not a mandatory requirement on ABC or SPS.
It's not a mandatory requirement, and it's not something that we've tended to use because of that. We've tried to come to agreements with the broadcasters about what actions they should take.
Yeah. And that recommendation from ACMA can extend to recommending an apology to the complainant, or that a retraction be published, or specific conduct of that sort?
It can, but again, there's no. The ABC would need to voluntarily accept that outcome.
Yes. If the ABC or SPS does not take a recommended action, then the ACMA may give the Minister a written report of the matter?
It can, it may give the Minister a written report. As I mentioned, though, that it is not a power that's been used very often. I think the only time it has been used that we could find was some considerable length of time by our predecessor organisation. As I mentioned, what we've tried to do is where we can seek agreed measures from the ABC and SPS, so that we're looking at what they can put in place for future compliance.
Now, coming directly to the way ACMA deals with complaints about breaches of the ABC's Code of Conduct or the SPS's Code of Conduct, is it right that the ACMA reviews complaints raising concerns about anti-Semitism or other forms of racism in the context of a Code of Conduct complaint, and then decides whether to open an investigation?
So when we receive a complaint, we firstly do a bit of a triage on that complaint. One, to establish whether we have sufficient information from the complainant. Secondly, to make sure that it is within our jurisdiction, given the constraints on that as well, and to ensure that the complainant has been to the broadcaster in advance. So once we've established that information, we'll also then turn our mind to the provisions of the code that the complaint may relate to. Often a complainant will have read the code and will have suggested to us where their concerns lay. Sometimes those complaints are more of a general nature, so our team goes through and assesses against the ABC and SBS code what are the most relevant clauses of those codes against which a consideration should be given. And as I mentioned earlier, that tends to be relevant to the Commission around impartiality and accuracy, or harm and offence. We will then move to carry out an initial assessment, so that will involve our teams listening to the broadcast or watching the broadcast, considering the responses that have come from the broadcaster back to the complainant, which is the loop back for them going to the broadcaster, and we will make an assessment through that process as to whether we have enough information to decide the merit of the complaint, whether we think there is potential evidence of potential non-compliance. We may end our consideration at that point, or we may move to formal investigations where we seek further representations, for example, from the broadcasters.
Is it also right that when investigating a complaint, or when deciding whether to investigate a complaint, you consider whether to do so would be in the public interest, having regard to the...
That's the overriding provision in the BSA, that our investigations should be directed towards the public interest.
If an investigation isn't carried out, you do create a document recording reasons for that?
We do. We have a complaint investigation assessment documentation which describes our a process of thought and our reasons either to move to investigation or to not move to a full investigation.
You've provided in your statement some statistics about the complaint process between 1st of January 2020 and the 25th of May this year, and you refer to 140 investigations being commenced by ACMA following the completion of 898 complaint assessments. Is that right?
I believe that's correct.
125?
Thank you. That's correct.
Yeah. Is that the total number, or is that the national broadcaster's number?
That is the total number.
And so it's a rate of about 15.6% of commenced investigations compared to complaint assessments received?
It is fair to say that we do many more complaint assessments than we do investigations, mainly because that complaint assessment is quite thorough and does involve us looking at the program, assessing it against the code and considering the responses from the broadcasters. We find that in the vast majority of cases, once we have done that assessment, we can settle the outcome at that point, and there's no need for additional investigation. So it's a large part of our work is that initial in-depth assessment, and then if we need to move to, we will move to investigations.
And that investigation involves responsible officers from within the authority looking at the program, seeking comments from the broadcaster, investigating the surrounding context, is that right?
Indeed, and it may require additional research by the team as well to be able to... I'm reflecting on some of the quite complex investigations we've got into around where there's been a complainant putting forward that there's been matters of complaints against accuracy and impartiality, where we can get into quite detailed investigation about what is accurate.
You've referred in your statement to, I think, the standard procedure to publish all investigation reports that are completed, is that right?
We do. Our standard process is to publish full investigations report. My only proviso on that is that in certain particular circumstances we may not, and that's predominantly where it may affect a person's privacy.
You've also referred in your statement to the KPIs for completing investigations, and you set out that the objective is 90% completed within 6 months, 95% within 12 months, and 100% within 18 months?
That's correct.
And over the last 5 or 6 years, have those KPIs been met?
I think we've had a couple where they didn't quite meet the KPIs, but that's certainly what we aspire to. Content investigations are variable in their complexity. Sometimes it may be a very precise and very clear outcome, but as I mentioned earlier, in some circumstances where we've needed to look at programs, particularly say long form programs, major documentary program or a major current affairs program, where it may have multiple pieces of statements or fact which we need to investigate, it can take quite a considerable length of time, and we may need to seek advice from other parties.
Now, in approaching complaints about the ABC or SBS arising from alleged violation of their codes of conduct, is it right that ACMA applies the concept of an ordinary reasonable viewer?
We apply that concept right across the board.
Right.
So when looking at complaints around content, given that content can be quite subjective to people, we apply an ordinary reasonable viewer test to approach the matter not coming from our own personal perspectives, but trying to step back from that and take from the program what somebody, what an ordinary reasonable viewer would take.
It sounds like that audience expectation document speaks directly to that notion of what an ordinary reasonable viewer might think.
It does, and it's also a very consistent test applied by content regulators, and including the UK.
Is there any other documentary explanation of the ordinary reasonable viewer, or is it left to your judgment based on materials including the audience expectation document?
I don't have the precedent in my head at the moment, but there are precedent around it.
Are you referring to case law precedents, are you?
Yes.
Oh, I see. Right. And just for the record, I think that's Amalgamated Television Services in Marsden in 1998.
That's exactly the one.
But it was certainly not a viva voce test. So. In respect of the ABC Code of Conduct, can I just ask you some questions about that document? It's ABC.599.0001.0284. At a general level, how does the ABC Code of Practice compared to industry codes in terms of its detail and the way it addresses the subject matter at a general level?
At a general level, this version of the code, which is dated 1 January 2024, is a much shorter code than the previous ABC code, as you can see. And what the ABC decided to do at that time was to remove quite a great deal of detail from the code of practice and move it into editorial guidance, which I think the ABC raised with you yesterday.
Yes.
So what they wanted to achieve, my understanding was a code of practice that was quite short and could be readily understood by and easily understood by its audiences about how it would judge itself. But it's fair to say that much of the detail of how the ABC interprets that code of practice is contained in their editorial guidelines.
Yes. And from your perspective, has the ABC code got that balance right? That is, the balance between including matters in a code of practice on the one hand, or in editorial guidance documents that are separate from that on the other?
I think that's an interesting question for their audiences. I would say that it's sometimes a little challenging for the regulator to take into account our primary responsibility is to look at what is identified in the code of practice, but the ABC have urged us to also make sure that not only looking at the code of practice, we're also looking at their editorial guidance. Whereas with the other codes for, say, the commercial industry, we only really rely on the codes of practice.
Yes. And you may well be urged by industry participants, for example, a commercial broadcaster, not to look beyond the industry code of practice.
I think I would express that the commercial broadcasters would, of course, have their own editorial guidelines,
Yes.
but they've taken a different approach about making sure there's, from their point of view, sufficient information in those codes of practice for the regulator to just focus on those.
As you understand it, complaints connected with anti-Semitic content or conduct would, in the context of the ABC, commonly fall under the harm and offence provision in the code that's 2/3 of the way down this page.
That's my understanding, yes.
And you've said in your statement that in the context of the ABC, the ACMA considers the question whether there's an intrinsic capacity to cause harm and offence.
Correct.
And could you explain how that's applied or considered in practice?
I think where we turn our mind to there is what is the power of the statement to actually cause real harm or real offence, and also whether or not those statements are actually justified by any context that fits around them, which is very much what the code directs us to. But then I think Mr. Fang, in his evidence yesterday, pointed to some of where that might be further explored in their editorial guidelines.
Now, some of the other parts of the ABC Code of Practice as appear on that page include the accuracy, the impartiality and the fair and honest dealing provisions.
Yes, that's correct.
And you have also described in your statement how ACMA assesses accuracy across codes by considering the meaning conveyed to the ordinary reasonable viewer or listener, whether the content was factual and whether it was material to the broadcast to ultimately determine if the content was accurate.
Yes, they're I suppose the questions we ask ourselves as we think through coming to a determination about whether a particular statement or program was accurate.
And likewise, your description of the consideration that ACMA gives to consider whether a broadcast is partial, in other words, not impartial, is if it unduly favours one perspective over another, and in an assessment or investigation will consider whether the audience has been informed of principal relevant viewpoints on an issue of importance and with information that allows them to form their views.
Exactly. They're the questions we ask ourselves in coming to a view around whether a program was impartial.
You do observe in your statement that broadcasters are generally not obliged to allocate equal time to different points of view or to present every facet of every argument in a single program?
That's correct, yes.
Can I ask you a question about the SBS Code of Practice? It's STAT.899.0094.0002. Let's go to the next page, please. And the next page. So just from the table of contents, and you of course are familiar with this code, but it is substantially more detailed than the ABC Code.
It is substantially more detailed, and I think this was a revised code from 2024, and you'll see that what the SBS has also emphasised in that new code is a very strong emphasis in areas like trust, and then it is actually defined underneath that trust header what contributes in the SBS's mind to building trust with their audiences.
And as the regulator of ABC and SBS, or the regulator in the limited way that you've explained of the ABC and SBS, do you have a view on the relative effectiveness of the two sorts of codes?
I think I'd say that we probably find the SBS code easier to deal with as a regulator because it stands alone, like the commercial broadcasting codes. Whereas with the ABC code, it is a little more challenging for us, where we've got a code of practice and we have to look at the editorial guidelines as well. So I think in terms of effectiveness, it's probably something that it would be useful for the SBS and ABC to reflect on in terms of how useful their audiences find these codes of practice and how useful complainants find the codes of practice as well in finding their way through what issues they should be complaining about.
Yes. And can I take you to page 13 of this document? It's section 5.1, which is under the respect heading. That you're familiar with this part of the code?
Yes.
And you'll see at the end of the second sentence, after disavowing any material that clearly condones, tolerates or encourages prejudice or discrimination, the code refers to that not preventing discussion of issues relating to these matters, including in ways that may be provocative or satirical. And then the next paragraph goes on to indicate that SBS understands that different cultural groups have different perceptions and values. SBS may broadcast or publish content that directly challenges accepted cultural values where it is editorially relevant and justified by context. Is that a code provision that sits comfortably with the description you gave earlier of the ACMA's approach to the application of the reasonable viewer test?
I think we would, in assessing any complaints around this code, we would still apply the ordinary reasonably viewer test. It is, but we would also take into account the context that SBS is a slightly different broadcaster with a different remit and a focus on multicultural voices, so we would also take that into account as well. In terms of the prevention of discussion, across the board there are sort of well-established exclusions around things like satire and humour, that material can be used in those sorts of forms, but then again we would look at it as to whether or not that even within the constraints of humour, whether it could cause harm and offence.
Can I ask you about anti-Semitism and complaints ACMA might have assessed or investigated raising concerns of or related to anti-Semitism. First, can I ask, has ACMA assessed and investigated numerous complaints raising concerns of anti-Semitic bias in the reporting of news events?
As we've discussed previously, the anti-Semitism is not included explicitly in the codes of practice, but where we have turned our attention to in some of our investigations have been where the complainant has raised that concern, but we have considered that that concern relates to potentially a harm and offence provision or a accuracy and impartiality, and we have investigated matters in that regard.
And have you observed any trends in relation to either complaints or their outcomes since, say, October 2023?
I think I'd reflect that where we have seen complaints coming to us, as I mentioned earlier, some of those were out of our jurisdiction, so we couldn't handle them. But in many respects where we have looked at and done initial assessments, they've been, we've not been able to, we have formed a view that they would not meet the bar in the codes of practice. Particularly sometimes they may be a single comment in a whole news program or a particular comment, and that comment may be opinion rather than fact, and we need to look at fact rather than opinion. So we may form a view that we can't find a breach because it was an opinion given by somebody on the program, or indeed it may have been a very short mention in a much longer form program. So they're the types of things we've had to weigh up when we're looking at complaints that have come to us.
And just at the level of understanding the prevalence of complaints about possible anti-Semitic bias, is it right that the ACMA does not have any specific policy or procedure in place to record the number and nature of complaints about anti-Semitism, or that raise that as a
No,
aspect of
that's
the
correct. And I think that goes back to where we try and track complaints, sort of goes to what the code provisions actually are. And as the codes don't include a precise description of anti-Semitism, it's difficult to construct a complaints handling system that can track through those. But we do, of course, track matters of harm and offence. We have been, in recent times, our team initiated a review of some of the decisions we've made since 2023 around some of our investigations. We thought, given that following the Bondi Hanukkah attack, it would be prudent for us to look back around some of the investigations we've done to make sure that we haven't missed anything, or we don't need to revisit some material that we've looked at previously. So we are going through that process at the moment. We think it's something that we should do as a regulator. I think that's referenced in my statement at para 145.
Yes.
We also thought it would be useful to look back at the totality of the complaints we had. So often we look at an individual complaint and then the next individual complaint, but we wanted to consider, was there anything of a cumulative nature of those complaints that we received that we should be reflecting on, or indeed the industry should be reflecting on, or the national broadcaster should be reflecting on. So that review is progressing, and I expect it will come to fruition in the next few months.
So in respect of each of those reviews, will the report of the outcome or the report of the review itself be published by the ACMA?
We will.
Commissioner, I note the time I've got between 5 and 10 minutes left to go myself. Maybe best to press on.
I've got in mind to adopt the Friday banking afternoon approach, so we're going to continue, Mr. Lancaster.
Okay. Is it right that that those two reviews are being undertaken as we speak, as it were?
Yes.
In terms of material that you've already been able to identify in respect of the identification of complaints in respect of the Israel-Gaza conflict, you have done an assessment of those investigations,
Yes.
have you?
Yep. So what we're looking at in our review is really focused on material that may be offensive to the Jewish community, as well as complaint data relating to the Gaza and Israel conflict more broadly. So going back over the complaints that have come to us and assessing them a little more holistically.
I see. Separately to those current reviews, you've also identified in paragraph 169 a review of the complaints register that you undertook in answer to a question from the Royal Commission.
Yes.
And in that you looked at the complaints register to look at complaints that indicated possible allegations of anti-Semitic conduct?
We looked at it through the viewpoint of relating to offensive material and discrimination, as well as provisions relating to accuracy, fairness and impartiality.
Yes. And you identified 56 complaint investigation assessments in that category.
That's correct.
And in respect of those, there were 4 full investigations undertaken and 1 is still in train, is that right?
That's correct.
Yeah, so 1 of the 4 is in train, or there's a 5th?
One, I think it's one of the 4 is still in train.
And is it right that no complaints in this category of the 56 in-depth complaint investigation assessments resulted in any substantiation of a complaint in respect of either the ABC or the SBS?
That's correct.
Now,
And as per my statement, with the 56 complaint assessments, we came to a view after we considered in depth that that there was a low likelihood that the broadcast would be found in breach, and as I mentioned earlier, that predominantly was because it may have been something presented as an opinion rather than fact, or something which was not a substantial element of the program itself. It may have been quite minor.
thank you. Can I ask you, in respect of less formal engagement with ABC and SBS, have you adopted a practice of meeting with the managing directors of ABC and SBS regularly or occasionally?
I have met with the manager of the incoming managing director of the CO in the last 6 months. I've not met with Ms. Polfram, who's the incoming, the relatively new CEO of SBS, but I have met her predecessor on a number of occasions. We also, as an authority, invite from time to time CEOs of our major stakeholders, so be that broadcasters or indeed telecommunications companies, to come and talk to the full authority in a broad-ranging discussion. And of course, our teams have extensive conversations and ongoing conversations with the ABC and SBS on matters such as broadcasting investigations.
And in terms of the ABC and SBS in particular, I take it from your answer that there isn't an arrangement for regular meetings with either the managing director or editorial directors of those organisations?
It is more, it's probably regular in that it's probably once or twice a year.
And from ACMA's perspective, what's the value of meetings of that sort?
We always find those meetings extremely valuable. I think in terms of, as a sectoral regulator, it's incumbent on us to understand the industries that we regulate. So it gives us a better sense of what's happening in the industry, the challenges that the relevant stakeholders may be facing, but it also gives us an opportunity to put to them our own observations of, for example, either consumer or audience of concerns. So it's a useful dialogue.
Yes. Now, you say in your statement that the ACMA does not deliver specific training about anti-Semitism to its own staff, is that right?
At this stage, that's correct, yes.
Are there broader modules of staff training in respect of discrimination and prejudice to groups with protected characteristics, as they say?
The Australian Public Service Commission is developing a range of training focused on anti-Semitism, and that will be something that we will find very useful both internally for our own staff, but also when investigators are looking at content. So that is a work in progress at the moment. But of course, we have internal training on things like anti-discrimination, bullying, harassment, some of those things which may go somewhere part of the way to those considerations.
And are they in-house training arrangements, or are there external providers that are used?
Well, I think the Australian Public Service Commission has what's called the APS Academy, which is a sort of online learning environment. Our expectation is that there will be more bespoke training for the public service included in that, as well as the opportunity to engage with the Commission about any bespoke internal or external training that we require.
You say in your statement that ACMA has not adopted any particular definition of anti-Semitism. In other words, it hasn't adopted, for example, the IRA definition?
For our internal purposes, yes, but in terms of our broadcasting content functions, that really falls out of what the broadcasters include in their codes of practice and the definitions that they are using to either define anti-Semitism or the definitions that they're using to, within their own organisations, address anti-Semitism. So it's very much guided by what the broadcasters have put in place.
You've also referred to the function of the Australian Public Service Commission in this regard, because the APSC has published a circular titled Working Together to Combat Anti-Semitism in the Australian Public Service, and you note that the APSC was supporting the Special Envoy to develop guidance on the IRA definition for the Australian Public Service?
Exactly, yes.
And do you know the timing on the output from that process?
I don't have that in my pack, but I know it is a high priority for the Public Service Commission.
And in terms of ACMA being the authority and its staff, I take it when that is developed at the Commonwealth Public Service level, that will be something that ACMA will adopt?
We will accept it, absolutely.
You, from an earlier answer, I take it that you heard Ms Siegel's evidence yesterday?
I heard part of Ms Siegel's evidence, and my team have kept me up to date on most of it, I hope.
So you are aware of her expression of some frustration from the Jewish community in relation to the processes of ACMA taking time in resolution of complaints about, in particular, the public broadcasters?
Yes, I'm aware of that, and we're always looking at what improvements we can make to our processes, and I would say over the last 18 months we've done a significant amount of change to our processes for investigations. I think some of the complainants that come to us are frustrated by the co-regulatory approach as well. They find it frustrating that they might come to us and then we say, you must go to the broadcaster, and then they must wait until the broadcaster responds. And at that point, I think some people think, well, why do I want to now go back to ACMA and for us to go through our processes? Where we can, we improve our systems and process, but I think the Special Envoy's comments, when I considered them, I wondered whether they were a combination of frustration with ourselves, but also frustration with the regulatory framework.
Now, Dr. Rob Nichols gave some evidence last week recommending to the Commission that the Commission recommend to the Government that a licensing regime may improve regulatory engagement by social media platforms, and particularly those that don't take action in response to regulatory steps of the existing framework. And Dr. Nichols drew an analogy to the Telecommunications Act in that respect. You address in your statement the licence conditions that apply to broadcast licences, and you note that one licence condition that might be relevant to anti-Semitic content is the licence condition not to use broadcasting services in the commission of an offence against another act or a law of the state of territory. That's one mechanism.
That's correct, yes.
And you note that ACMA might investigate a licensee's compliance with licence conditions without the licensee having been either the subject of proceedings or convicted of any such offence.
Yes, and that has been proved through the courts that we have that capacity to look at those issues.
And ACMA also has functions with respect to carrier licences under the Telecommunications Act.
We do.
Do you have any observations about the extent to which licensed broadcasters and carriers respond to regulatory steps by ACMA in the current regime?
I'm not aware. I did not observe Rob Nichols' evidence, so I'm not across that detail.
Yep.
But obviously, both in telecommunications and in broadcasting, both are subject to licensing processes. The broadcasters are subject to license conditions. In telecommunications, I would just reflect that there's a very low bar in the telecommunications industry for entry to market, and those license conditions are quite light, much more on carriers than carriage service providers. I'd make that distinction. But obviously licensing is a core part of the regulatory framework for the sectors that for which we are responsible.
Thanks, Mr. O'Loughlin. No further questions.
Yes.
No, thank you,
Mr.
Commissioner.
Oh, no. Just perhaps while you make up your mind, Mr. Kaplan, if I can just ask you something unrelated to the matters that Mr. Lancaster's been raising with you, but it concerns ACMA's annual consumer survey. That includes measures of trust and of the reach of news media, is that right?
That's correct. So each year we do a consumer survey to consider a range of matters, not just in broadcasting, but really we've been asking in recent years around what are the levels of trust in news media in Australia, and what is the reach of that. Are people accessing more or less news media, and how is the delivery of that news media changing over time as we look at the shift, the radical shift from traditional broadcasting to online news.
Very broadly, Ms. O'Loughlin, if you're able to, can you say how the ABC performs on those measures of trust and reach in relation to news?
I think the ABC itself produces research which indicates that it has very high trust levels for news in particular. It's probably the most trusted news brand in Australia. I think that is also borne out by our research as well. And of course they have probably the most extensive television and radio network combined in Australia, so they have exceptional reach.
Yes, thank you. Mr. Kaplan.
I'll be very brief, Commissioner. I hesitated because I had understood that Mr. Lancaster would raise a matter about the second notice, but perhaps that could be...
I can certainly do that. There's no...
Thank you.
Just one point of clarification as I look. The second document I tendered at the very start of asking you questions, I think I referred to as a supplementary statement. It was in fact a written response to a notice of
That's
the Commission.
correct. Yes.
And you adopted its contents.
Yes, thank you.
Thank you, Ms. Thank you, Mr. Lancaster, and thank you, Commissioner. Ms O'Loughlin, you were asked a question by Mr. Lancaster about ACMA's power to determine standards for commercial TV and radio under the Broadcasting Services Act, where there's convincing evidence that an industry code's not operating to provide appropriate community safeguards. Do you recall that
That's
question?
correct, yes. I
You were
recall it.
also asked whether there were examples of ACMA invoking that power in respect of anti-Semitism, and you answered no, there's not. Why is that?
In regard to that, we would have to prove in evidence that the codes themselves were failing to deal with complaints around anti-Semitism, and we have been able to deal with such complaints under each of the codes, not necessarily in a straightforward manner, but we've been able to, I think, turn our minds to those types of complaints successfully under existing codes. So where there may be some perhaps benefit, the industry is re-looking at their codes and making those provisions perhaps more explicit. It hasn't constrained us with being able to deal with complaints of that nature.
You were taken to paragraphs 126 and 125 and 126 of your witness statement, where you detail the number of complaints, complaint investigation assessments and investigations carried out by ACMA since 2020. Are you able to say roughly how many complaints ACMA has considered since October 2023?
Yes. So since 2023, we've received more than 2,000 complaints, and that's right across the board of all the things that are covered by codes of practice, be that advertising, be it accuracy and impartiality, be it classification. So right across the entire scope of those. We've undertaken 350 in-depth analysis based on those complaints, and we've undertaken 50 formal investigations on those matters. And as I mentioned earlier, all those investigations are made publicly available, except where we think there are implications for personal privacy.
Yes, I was going to ask you about the transparency of ACMA's processes as they pertain to complaints.
Yes.
Complaint investigations.
So we
and
have,
complaint
we've
outcomes.
always made our investigations public, but over the last 12 months we reflected on some of the additional information that our colleague regulator in the UK, Ofcom, provides, which also goes into those complaints that we have not investigated, to provide more public information about those and the reasoning as to whether or not we were proceeding with investigation, whether we've closed. So we've made that more transparent on our website over the last probably 8 to 12 months.
And finally, Ms O'Loughlin, you were asked a question about whether ACMA delivers specific training about anti-Semitism to its staff, and in response you mentioned that the Australian Public Service Commission is developing training focused on anti-Semitism. What does ACMA propose to do with the Commission's learning products once they become available?
I think we will, I'm also the accountable authority of the organisation, so we will turn those into policies and procedures that apply to all our staff, and we'll also make training available for all our staff based on the APSC materials. We already access things like the SBS Inclusion Program, but we see that the Public Service Commission's materials will be comprehensive for our staff, and will also inform the thinking of our investigation staff.
Thank you, Ms O'Loughlin. Thank you, Commissioner.
Yes, thank you, Mr. Kaplan. Anything arising?
No, thank you.
Thank you, Ms. O'Loughlin.
Thank you,
You are
Commissioner.
excused. And as indicated, although it's not such a not such a holiday, but I will adjourn the commission until 10 a.m. on Monday in Melbourne.